for judgment.
Anybody connecting? Also, it's from here. Sorry, it's from here. I am pronouncing the division. I've been authorized to pronounce by Mrs. Michael, sir. We do not find any scope for interference with the conviction and sentence by the impugned judgment and order dated 16/4/2025, passed by the learned special judge NDPS, Champai Judicial District, in Champai PS case number 44 of 2019, and accordingly the appeal is dismissed.
Obliged.
Motion, item 1.
Who mentions?
Lordship, if I may seek your Lordship's indulgence in mentioning Part 2, item number 5.
Yes. Any mentions are there? Yes. Which matter? Which
Part
item?
2, item number 5, my lord.
Yes, yes.
My
Fine.
lord, I've taken the consent of the other party, so if this matter may kindly be taken up after 3 weeks.
Okay. You are for the government.
No, my lord, I'm for the respondent number 1.
Oh, for okay. It's okay. Yeah, it is a state appeal, right?
State appeal.
Okay. No problem. After she's seeking after 2 weeks. No problem. Learned counsel. Your good name, please.
Daphne Shoitongi, my lord.
Learned counsel appearing for the respondents.
Respondent number 1, my lord.
Respondent number 1 seeks an adjournment of 2 weeks in this matter. In this criminal appeal against acquittal filed by the state. Okay. Prayer is allowed. List the matter after 2 weeks.
Obliged.
Motion, item 1.
Yes, sir. This also.
Your Lordship, in this writ petition,
Part-time
we're seeking-
lecturers.
yeah, part-time
right? Yes, yes.
part-time lecturers, part-time assistant professors. Now they have been designated as such. They were appointed on the basis of the advertisement, which was floated in the year 2011.
I see.
May I take a Lordship to Annexure 1. Advertisement number 1 of 2011-2012. It is dated 3rd October 2011. And required educational qualification, as shown here, is master's degree in its field with 55% marks at the master's level. And having knowledge of Mizo language
Up to middle
up
school.
to middle school standard. And the remuneration is 250 per lecture, per and
Or 10,000, whichever is less.
10,000, whichever is less. Your Lordship, they have been working on the basis of the appointment, which was made pursuant to the recommendation made by the selection committee. And they continued from year to year. They have been allowed to continue from year to year. And in fact, they are in the BCA department, that is Bachelor of Computer Application. They have been teaching there for a number of years now.
Advertisement is of 2011 itself, right?
2011.
Now
yes,
the
sir.
thing is that now they want to have a regular recruitment.
Regular recruitment, that is from part-time, the next upgradation will be as a contract, on contract basis, as a contract teacher. But for the purpose of contract appointment, there has to be a clear vacant post. Clear vacant post was not there prior to 2025. And they were fighting for creation of 7 posts.
So, as I understand it, the part-time lecturers were advertised, they underwent a selection process, they
Yes.
joined, and at that time, the next upgradation was for contractual post, and
Yes.
contractual posts were not available all these years. 2025, the posts are available,
Yes.
and the authorities want to go for regular recruitment. Right?
Yes,
That's what
yes.
they want.
Regular recruitment means the petitioners had applied for their contract appointment.
Okay,
But in the meantime,
they have been discharged.
the order,
Yeah,
they have been
MP,
informed
Are
that-
they are they also, have they also issued a fresh advertisement to fill up the post on a regular basis?
No, not on that. I mean, prior to this, in 2007, 2008, they had advertised the post for filling up on the basis of the same recruitment process. And under AICT norms, first class degree in their concerned subjects that was required. And all the petitioners have the required qualification even under AICTE norms. And since BCA has been brought under the purview of AICTE from the UGC, now that they are under the AICTE regulation. If I take a Lordship 2, Annex 12,
In Excerpt 12.
Annex 12. Annex 10, in fact, is a Lordship UGC Regulation 2010. Even under UGC Regulation 2010, the required qualification for appointment as a regular assistant professor is as shown under page 68, Your Lordship.
68.
68.
Qualification, first
Yes.
class master's degree.
First class master's degree in appropriate branch of engineering and technology. The degree which the petitioner
Associate
holding,
professor, PhD.
yes, associate professor, PhD. Now
Experience
that's,
of 8 years in teaching.
yes, for the
continuing-
purpose of further upgradation to associate professor, they'll require PhD. But for the
For
purpose of
assistant
appointment
professor,
as assistant professor,
it's not
even
necessary.
on regular basis, the degree, whatever degree and qualification that they are holding is sufficient. Now they are working as part-time assistant professor at a fixed remuneration. Now they have been continued and they are allowed to continue from time to time on year-to-year basis.
Right.
Now, Your Lordship, there was a so-called notice which they had responded.
Page 94 is one of them.
Yes, Your Lordship. Page
Reply to.
90,
This is the
93.
reply. This is the reply.
93 is the so-called notice, Your Lordship. At page 93, Annex 24. This is one of the petitioners. A similar notice has been issued to all of them. And here it has been stated, whereas you have been engaged as part-time assistant professor with effect from 1/4/2015, despite not having the required educational qualification mandated by UGC regulations, that is PhD, net, SLET, set for engagement to the post of assistant professor. And whereas you have been given several chances to acquire the required qualification with effect from 1/3/2018, and whereas the competent authority, after due consideration, is of the opinion that the intent of extending the engagement period to acquire the required qualification has not served its purpose, and is contemplating to reconsider the engagement period currently approved till 28/2/2026. Now, therefore, you are directed to explain in writing as to why your engagement as part-time assistant professor shall not be terminated. The explanation should reach the undersigned within 15 days from the date of issue of this letter, positively, failing which your case will be considered ex parte. Explanation can also be sent via so and so. And this was dated 3rd July 2025.
You just shown me the qualification which is there. That was stipulated by the UGC.
Yes,
You just showed me.
yes, I have shown at page 95, page 95.
Okay.
Page 95, this is what we have stated here in this application, reply affidavit. No, reply to the so-called notice. Your Lordship, the qualification under UGC, which I have earlier shown to Your Lordship.
What is the, where is the impugn order?
the impugned order, in fact, is, Your Lordship, after this, while they were expectantly waiting for the
After the reply.
extension of their service and regularization for appointment on contract basis. In fact, what they have sought for in this reply at page 98, Your Lordship, page 98. What we have stated here is that, in view of the facts and circumstances stated above, I am honestly soliciting your kind authority to take necessary steps for allowing me to continue in the said post as part-time assistant professor in Department of BC at Government Scholarship College till 28/2/2026, and thereafter to accommodate me to the same post as assistant professor on contract basis, and thereafter to allow me to continue till my regularization in accordance with the Government of Mizoram Regularization of Contract Employee Scheme 2008 against one of the 7 sanctioned posts stated earlier. The 7 sanctioned posts, Your Lordship, that was created in 2025.
Yes. So their their present term is till 28th of this month.
Yes, 28th of this month. So since by this letter, they have been informed through the principal at page 106
For discontinuance.
for discontinuance of engagement of unqualified part-time professor in the government college. So the list of those so-called unqualified part-time assistant professors are there at page 107. Your Lordship, by this letter, if this is allowed to stand, Your Lordship, the decision of the state respondents is that their services, even as part-time assistant professor, will be terminated with effect from 28/2/2026. And they have been working as such for the past so many years, and now it is not that they are not eligible for regular appointment. They are eligible for regular appointment as per the AICT norms or even under the UGC regulations.
Anyway, so Madam Carol, you are appearing for the state. What is your take at this stage? Because we can of course examine this, but the only thing is that their present term comes to an end on 28th of this. So basically, what is the state seeking or desiring to do? That fill up this post by regular appointment?
For that, I will have to obtain instruction.
Yeah. Because the state, per se, the state cannot be prevented from undertaking an exercise of regular appointment. However, these petitioners can definitely participate in such regular appointment. However, they are seeking migration to the category of contractual appointment, and there is dispute regarding the qualification. As per the document shown to me, can we see the document again, sir? That UGC document. It is at page
95.
No, the UGC, which we had seen. Before that, we had seen one document.
Yes. 67.
67. No, qualification we had seen. Oh yes, this one, 68, page 68.
Oh, 68.
Minimum qualification for teaching faculty in so and so, so assistant professor.
Yes.
Yeah, as per this qualification, the PhD or NET is not there.
Not required for appointment to the post of assistant professor.
So this is one dispute. The second dispute is that they are seeking migration to the category of part-time,
From part-time to contract.
contractual.
Yes.
But the respondents are seeking to undertake an exercise of regular selection.
Not so much, Lordship.
Not so much.
Since the term is coming to an end,
They are being
They
discharged.
have stated
The state is not really undertaking an exercise of regular appointment, but they are being discharged because they are being held to be not having the qualification.
that is according to them, yes.
Madam, kindly take
If
some
I take a lordship-
preliminary instructions. Yes.
If I take a lordship to the office order, which is at page 54. This is in respect of the provisional interest seniority of part-time assistant professors.
Page?
Page 54. Even those
Yes.
At page 58,
Gradation list.
58, yes, BCA at 84, 85, 87, 88, serial number. A lot of people see against the names regarding eligibility. It has been stated that net is not required. Net not required. Not required in respect of all those. And even in the MIZO department, net is not required. And in BCA also, since they all have this requisite qualification as per the UGC regulation, according to this also, it is stated that net is not required. And now they have been sought to be discontinued because they do not have net or PhD in the meantime. And if I take a lordship to page 69, this is under AICT regulation of 2010. Now that the petitioners have come under AICT regulation, at page 69,
Okay.
Lordship,
Yes.
page 70 is the faculty norms for the purpose of the program of MCA, Engineering Technology,
BCA.
under MCA. MCA is a postgraduate course. Now, the petitioners are going to teach, and they have been teaching in BCA.
BCA.
BCA is a graduate, undergraduate. Now, even in MCA, for the purpose of appointment as an assistant professor, the requirement is the BE or BTech and ME or MTech in relevant branch with first class or equivalent either in BE, BTech or ME, MTech. So, with MCA or MCA with first class or equivalent with 2 years relevant experience. So this is the required educational qualification to teach even in the MCA program. For the purpose of BCA, no specific program has been made under the
AICT.
AICT.
Regulations.
But that since they have been brought under the AICT, the proposal has been made for such programs. So in view of all this, Lordship, the consistent stand, what the state government have been doing is that by applying the AICTE norms, even in the year 2008, at page 75, Your Lordship will see,
Page 75.
page 75, Annexure 15. Here it says, a meeting of Departmental Selection Committee was held to consider filling up of 4 posts of lecture in BCA department with a fixed pay of rupees so and so. The posts are to be filled up 100% direct recruitment from eligible candidates having first class in Master of Computer Application, first class in BE, BTech Computer Science, first class in MSc Information Technology, Computer Science, first class in Master of Computer Management. So this is the criteria which was adopted even in the year 2008. And this is exactly what has been stated in the MCA program also. And even under UGC regulation, no other requirement has been made, apart
Just-
from first class.
Just a minute. I'll have a.
In the meantime, at page 77, Your Lordship,
Just a minute. Page 77.
Page 77. There's a letter to all members of the Academic Council of MZU on the subject of circulation of the final minutes of the 44th meeting of Academic Council.
The so-called notice says that there are two things that that this qualification has been held to be essential according to
That's
the
true.
authorities' interpretation, and they have been given time to acquire that qualification since 2018. So that is the tone of their notice, that it has not served the purpose. So despite being given time, they have not acquired.
That is what
So
they mean, the
they have been
stand of the
sought.
state government.
Yeah, that's
But
the-
UGC and AICTE, they have all said that
Per se-
essential and
Yes.
it's not desirable. The essential qualification required for appointment to the post of assistant professor
Right.
is so and so. And here at page 78, 79, the Lordship will see the decision of the Academic Council of the Mizoram University,
Yes.
MZU, where at AOB2, the Lordship will see at
Page 77?
79.
79.
Yes. Page 79, Lordship will see. Proposal for reallocation of BCA under School of Engineering and Technology. School of Engineering and Technology. Bachelor of Computer Application is currently assigned under the School of Physical Sciences and a board
Yeah,
of...
that's correct, actually. It should be
All right.
reassigned.
Then Academic Council resolved to approve reallocation of Bachelor of Computer Application and the Master of Computer Application, and Master of Computer Application and the School of Engineering Technology with immediate effect. And there's a letter from the UGC addressed to the Vice Chancellors of all the state public universities and principals of all colleges at page 82, Your Lordship, wherein it's on the subject of bringing UGC courses in management and computer applications under AICTE regulations. At the end of the letter, it is stated, state public universities are requested to communicate the above information to all its affiliated institutions which are offering or intend to offer program or course in BBA, BMS or BCA for compliance. AICTE may be contacted for further necessary action.
What is the page number of this order which you are seeking interference? It's 9226 and 4226. 4226 we have seen, 9226. The impugned letter, 9226.
Impugned, yes, Your Lordship.
It is at page,
Page 106, 104, and 106. These are addressed to the principals of Government Scholarship College and Government Champai College, because they are working under the, say, two colleges.
and 4/2/2026. 4/2, the order dated 4/2. Is that page number?
942.
The two impugned orders. This is one impugned order, this is 9/2. And the 4/2 is the prior letter to that. The receipt from the Undersecretary, I think, that letter.
That's it. Nine two. What a 9-2.
No, 4/2.
It may be mentioned that proposal for continuing unqualified position under government can be created by 4/2/2026.
Letter dated 4/2 issued by
4/2,
Undersecretary.
yes. We have not enclosed this, Your Lordship. It's on the same
Okay, it's
subject.
not enclosed, right? Anyway. So, Madam, you take instructions regarding, and please also, you can just note it down. You can take instructions on these two aspects, that the proposal is with regard to, first you take the instructions about the qualifications, that the materials Learned Council has shown, they indicate that that is not an essential qualification, but their termination is sought to be on the basis that they do not have that essential qualification. Second point is that the government is proposing to having a regular selection, or because in that case they can also participate, or they are just simply focusing now on terminating or discontinuing the part-time lecturers on the ground of not having qualifications, right? I'll not say in the order, you just take instructions. Heard, so Learned Senior Council for the writ petitioners. The instant writ petition has been filed invoking Article 226 of the Constitution of India by the petitioners, agreed by the letter dated 9/2/2000, letter number, you just see from para 22 of the writ petition, letter number so and so, dated 9/2/2026, issued by the Director, Higher and Technical Education, Mizoram, regarding discontinuance of part-time assistant professors in the government colleges, full stop. The petitioners are also agreed by letter number so and so, dated 4/2/2026, issued by the Under Secretary, Higher and Technical Education, Government of Mizoram, about discontinuance of part-time lecturers purportedly not having essential qualifications, full stop. The facts in a gist are that the petitioners were selected as part-time lecturers by a process in 2011 by pursuant to an advertisement dated 3/10/2011, and they have been engaged from time to time with the present engagement term expiring on 28/2/2026, full stop. The main ground on which the petitioners are sought to be discontinued is that they do not have the qualification of PhD/NET, SET/ACT, and that these are essential qualifications, and that these are said to be essential qualifications prescribed by the UGC and the AICTC, All India Council of Technical Education, AICTC. Drawing attention to one of the annexed documents, the Learned Senior Council submits that the essential qualification for assistant professor in engineering, in colleges of engineering and technology is a first-class master's degree in the appropriate branch of engineering/technology, along with some desirable qualifications mentioned therein, full stop. The Learned Senior Council also draws attention to the document pertaining to qualifications of assistant professors for teaching in the program of MCA, and points out that therein also there is no stipulation regarding PhD/NET/SET, full stop. In this backdrop, the Learned Senior Council submits that it is not a case of the petitioners as part-time lecturers in the discipline, part-time lecturers in the discipline of BCA not having essential qualifications for teaching in the said post, and that rather the petitioners as part-time lecturers should now be upgraded to the post of contractual, at least to the post of contractual lecturers. Full stop. You are representing all the respondents. Ms. Caroline Larned, government advocate, appears and seeks to represent all the three respondents. Extra copies may be furnished to her. The learned government advocate shall take instructions regarding the same. If you want, you can file a counter also. But otherwise, as I said at the beginning, we can always, examine this issue in a flexible manner. But their term is coming to an end. That is why initially we are talking about instructions. Okay. For the moment, the respondents shall take instructions from the respondents, the learned government advocate. The respondents are at liberty to file any written pleading as well. Please the matter on.
In the meantime, Your Lordship, I have met interim prayer.
Interim prayer, because the term is coming to an end, right?
Yes.
On this thing. So, by way of interim prayer, you are seeking continuance.
Continuance, yes, Your Lordship.
The learned senior counsel, you take instructions regarding that also, and that will be opposed, I believe, in the government. But the learned senior counsel submits that pending adjudication of the projected issues in this writ petition, the petitioners may be allowed to continue as part-time lecturers as their term is coming to an end on 28/2026. The learned government advocate shall also take instructions regarding the said on the said subject. Let us fix it on 26. On that day, I will consider.
Your Lordship,
We will get some feedback from the other side a little bit. Today is 25th.
No.
Today
Today is 25th.
4th, yes.
Tomorrow it will not be possible.
Your Lordship,
Tomorrow, that's
I'll be out of station by 27th.
Because I don't know, one day will it be possible?
No, my lord.
You may not, they may have some difficulties. 26th,
Tomorrow. Let them come back tomorrow.
I can fix it, but they have problems.
29, oh lord, February. Lord.
They have problems. Can I fix it on 20 tomorrow?
Tomorrow, lordship, tomorrow it will not be possible to get instructions and then file.
I can fix it, but I don't know whether they will be able to get the instructions. Okay, let us fix it and then you take a chance. And if not, then we'll fix it on.
Lordship, if it can be fixed on 2nd of March.
2nd
No,
March
one
is
day I
Monday.
want to fix before the term is over. Okay, 27, 28 is holidays, right? One day
Yes.
we fix it before their term is over, and then
Let it come again tomorrow.
as their term is, how is the extension given? By a fresh process or just like that, by administrative order?
It's by a fresh process.
Fresh process.
Yes.
Then I pose a question as to whether extension would be possible even by an interim order. I'm just posing a question.
Lordship,
If it's a fresh process, then
fresh process in the sense, since they have been
every
recommended,
time
they have
their engagement is for usually
been- for 1 year
one
term.
year, then fresh process.
Yes.
And that is how they have been continuing
That
since
fresh process
2011.
means that order comes even at a later stage, but they continue. Even when they are not
I see.
shown to be continuing, but they continue because if the petitioners are ousted by this, on the basis of this impugned letter, then it will necessitate the state government to recruit them afresh. The question is, it's not required that they should be recruited afresh, but that it's a routine manner.
That is why actually I had asked that question, that these posts are, the plan is to have a regular recruitment where they can participate, of course, subject to the required qualifications, the actually required qualifications, and or whether they are only sought to be terminated because of not having the qualifications. That's the thing. termination
Lordship-
followed by,
Lordship,
the plan of the government is to, terminate them, followed by a regular process. That is what they have in the pipeline, or they are just, as the government authority has expressed regret regarding this non-qualified part-time lecturer, so they are seeking to discharge them.
all those other part-time lecturers or assistant professors who were found to be qualified, they were upgraded as
Contractual.
contractual.
And
Professors.
petitioners are also seeking that.
Yes,
They are also seeking that.
yes.
So you guide me, I can fix it tomorrow, but fixing is not a problem. But the thing is that whether, should we just fix it and take a chance?
Yes, madam, I will try to get oral instructions.
Okay, let us fix it tomorrow.
All right.
Otherwise, may have to accommodate one day,
So far as the
You may-
interim
you-
matter is concerned.
If possible, make an alternative arrangements for day after tomorrow, in case you are not there, in case we have to fix it again day after tomorrow, right? This item 2 is also same?
Item 2 is more or less same, but the thing is that they are
Tomorrow.
shown to be unqualified, and they have accepted that they are not qualified for appointment as regular assistant professor,
Contractual.
contractual or regular assistant professor. But in the meantime, since they have been informed that they should acquire this eligibility, that is by having PhD or NET, they have been trying their best. And what we have stated here, in para 12 at page 9,
AC a little bit.
what we have stated here, so far as the efforts given by the petitioners,
Para 9,
para 9, para 12,
Para
at page
12.
9.
that.
May I take a lordship to sub para 1, 12.1. Lordship, the petitioners have been working as part-time assistant professors, and they are required to obtain their PhD degree in the meantime. But they are not given any study leave also. But in spite of all such hurdles, they've been trying. Here I have stated in sub-para 1, in this connection, petitioner number 1 has been enrolled as PhD scholar of Mizoram University in the Department of Environmental Science under the supervision of Professor Lalun Tuanga under registration number so-and-so, with his research topic assessment of water quality, vector-borne disease and microclimate in the vicinity of Kelungli Damchampai. Number 2, petitioner number 2 is also pursuing her research PhD in botany under supervision of
All are
Dr.
pursuing.
so-and-so. And petitioner number 3 also started enrollment of Doctor of Philosophy program in the Department of Economics at NIT Mizoram in 2017. However, due to circumstances beyond her control and on the advice of her supervisors, she had applied for readmission in 2023 and subsequently transferred her registration to Apex Professional University, Pasigat, Arunachal Pradesh, where she has been enrolled under so-and-so. And now, so far as the petitioner number 4 is concerned, he had started his PhD program in the Department of Physics at Mizoram University in the month of August 2018 under registration numbers and so with his research topic, determination of kerosene in gasoline and its impact on vehicular engine emission. And now he has completed all the requirements for submission of his PhD thesis. In addition to completing research work, he had also published 4 papers in Scopus indexed journals, of which 3 are in SCI journals, and had also published 2 conference proceedings, and also presented papers at 5 international seminars or conferences. So this is the effort which the petitioner have been given for obtaining PhD. They know that without obtaining PhD degree, they will not be able to get the regularization, not even contract.
But as per the document which has been shown,
Yes.
which we have discussed, the PhD is not essential.
No, that is in respect of this arts line.
Okay.
That is engineering technology.
Engineering is not necessary.
That is not
essential.
necessary.
But for other disciplines,
For
it is
other
necessary.
disciplines, it is necessary, except in Lusai, Mizo.
Okay.
And here, Your Lordship, the last extension which was given the last extension that is page 56, Your Lordship, Annex 10. This is on the subject of approval of continuous engagement of 29 numbers of unqualified part-time assistant professors under government colleges. Sir, in inviting a referential letter number so-and-so, I am directed to convey herewith government approval for extension of engagement period of 29 numbers of unqualified part-time assistant professors of various government colleges for a period of 1 year with effect from 1/3/2025 to 28/2/2026 on humanitarian ground to enable them to obtain the required qualification as below. The names of the petitioners are included here.
Okay. So similar but slightly different footing.
Yes, slightly different. Only thing is that the petitioners have admitted and accepted that they are as yet not qualified. And for that, they have been trying. And
So they want more time.
taking the first recruitment as a case, Your Lordship, they were required not to have the PhD or NET or any other thing as a part-time assistant professor. But for the purpose of continuance as part-time assistant professor, no further degree would be required. But for the purpose of their elevation as a contractual professor, assistant professor, that will be required.
For all these subjects.
All these subjects. And even those...
But not technology.
Not technology. Even those who were recruited along with them and those who had obtained PhD degree or NET, they have been elevated to the higher status, that is contract, and even regularized them. So far as the petitioners are concerned, they are 29 here. They have not been able to obtain the PhD or NET, and they have been trying their best. And some of them are on the verge of submission of their thesis, and some of them are still struggling. They had their registration for research. With all difficulties, they have been pursuing the research. So, since the extension is on humanitarian ground, let it continue on humanitarian ground, so that in the meantime, since they have taken all efforts, they'll be able to complete and obtain the required degree, so that they also will be given appointment on contract basis. Once they are given contract basis appointment, Your Lordship, there is a provision for regularization of contract
In terms of the
appointees.
scheme.
Yes, in
Mizoram
terms of the
government.
scheme.
Anyway, so heard, this will be, what you do is that earlier order, you write same order. And below that, you take the dictation. Then I'll adjust it. Okay. The petition, the writ petitioners herein were selected as part-time lecturers pursuant to an advertisement dated 3/10/2011, and so they have been serving in different disciplines,
Yes,
right? Full
yes.
stop.
Botany, economics, and physics.
The writ petitioners are aggrieved by the order dated 9/2/2026, issued by the Director, Higher and Technical Education, Mizoram, whereby unqualified part-time assistant professors under the government engineering colleges are sought to be discontinued, full stop, discontinued beyond the present term of 28 to 2026. The petitioners have been granted the various extensions, with the last extension being up to 28 to 2026, full stop. It is stated and submitted that all the 4 writ petitioners herein are enrolled as PhD students and have been trying their best to complete the same. And therefore, the action of the Education Authority in seeking to discontinue them after the present term has caused them prejudice, and that the last extension was the last extension was considered on humanitarian grounds. It is submitted that the petitioners are in the process of acquiring the necessary qualification of PhD/NET/SET required for the disciplines pertaining to them, but that while their efforts to acquire these qualifications are already in process, the respondent authorities are seeking to discontinue them at this stage. The Ms. Caroline Land, government advocate, appears for all the respondents, yes, right? And extra copies may be furnished to her. This also you will take instructions same day. Instructions may, okay. Or should we fix this on 26th? Can we fix this on 26th? Because again we have that same deadline. Anyway, let's fix it tomorrow. But here the situation is slightly different. You know, it's a question of whether they're seeking some more time to get the qualification. There is no dispute about the qualification, right? Or should it be fixed on next week? But that will be beyond the term. Can it be fixed on 2nd March? This one.
2nd of March.
This one, this particular one. Or you'd be agreed by that?
Lots of event. If there's an interim order, lots of.
Interim order. I am not inclined to pass right away. You know, you take some instructions. Okay, tomorrow. Will it be burdensome for you? 2 matters.
From the same department.
I will try to get.
You try. Otherwise, we will adjust it to day after tomorrow.
God bless.
Commission, item 3.
Because this fell down, I think. Oh, so sorry. No, it's a part of the file. One file paper has fallen down.
May I please, Your Lordship? My Lord, in this case, there are certain developments in the sense that the matter pertains to claiming of compensation due to dispossession of the petitioner's land on account of construction of Kaladan Multimodal Transit Transport Project. And my Lord, earlier there was this draft award number 1 of 2022, which was already approved by the respondent authorities. But recently, my Lord, the said award was revised by draft award number 1 of 2026. And my Lord, if you may kindly see letter dated 30th.
Just a minute. Let me
30th January 2026, my Lord.
Have a look at the synopsis once.
At this stage, my Lord, I'm only seeking time for filing additional affidavit to incorporate the developments in this case.
Acquisition process has not been done. That is the grievance, right?
Yes, my Lord.
Acquisition process has not been done.
It's under process.
It's under process.
Yes, my Lord.
Resubmission.
And recently, my Lord, by this letter dated 30th January 2026, the DC Longtai District has sought for approval of the draft award number 1 of 2026. Earlier, the previous award was 1 of 2022, which was already approved. and awaited for sanction.
This
but-
is a draft award of 1 of 26.
Yes,
He
my
is
lord.
seeking approval for the same.
Yes,
That
my
means it
lord.
has progressed.
Yes, my lord.
It has
So we are
progressed.
waiting for the approval of this.
Okay, okay.
And if I may grant a 3 weeks' time, so that I will obtain the latest development to the status of this.
Ma'am, you
I'm appearing for the state respondents, my lord.
state, all the state respondents.
Yes.
Union of India. Heard, huh? State respondents and Union of India. No private respondents, no?
No private
Full
respondents.
stop. The matter in a very nutshell is that lands are sought to be acquired for construction of a two-lane highway from NH 54 near Langtai, AOC, to the Indo-Myanmar border in Mizoram as part of the Kaladan Multimodal Transit Project Road, right? Within bracket KMMTTP road, full stop. The petitioners are, however, aggrieved that despite their lands being part of this project, the acquisition process and consequent compensation thereof has not proceeded, full stop. Today, the learned counsel for the petitioner, you have submitted, no? This one?
Yes, my lord.
Have submitted a copy of communication dated 30/10, later dated 31/2026 from the district collector, Langtai district, to the Under Secretary, Land Revenue and Settlement Department, Government of Mizoram, whereby he has placed a draft award, being draft award number 1 of 26, pertaining to the acquisition of land of amounting to value so and so. Huh? 1,47,85, 64, 185, 185.04, full stop. In the context of the same, the learned counsel for the writ petitioners submit that he may be given 3 weeks' time to gather more information regarding the aforesaid developments. Full stop. This is a positive thing. I think it's moving
my
in the
lord.
right
Hopefully,
direction.
yes.
So anyway, full stop. List the matter after 3 weeks. That will
Duly
do,
obliged.
right? After 3 weeks. Can I keep this in the file?
Yes, my lord.
Item 4.
May I
There
please
was
your
a-
lordship?
Yes, yes. There was a direction to consider.
My lord, this is the judgment of 6/5/2024. And why this judgment, my lord? This is a common judgment of the WPC number 64, 2023 and WPC number 52, 2022, seeking for counting of their past service for the purpose of upgradation to senior citizen grade. And my lord, pursuant to this judgment, my lord, the other writ petitioners, why this common judgment was already complied and implemented. Therefore, they enjoy the benefits of this judgment. But as for the present petitioners, my lord, it has been delayed. And
Others have been given the benefit.
yes, my lord, I have already enclosed the compliance order also in my contempt petition,
Okay, I'll have a look.
which
Otherwise,
is at page
uh,
number 33 of my contempt petition.
33.
33 of my contempt petition, page number 33. And it's a 3.
I'll tag it also. I have a small stapler here. Helps. That's it. No, I'll give me later also. This is a communication of 4th December. Same judgment, huh?
Same judgment, common judgment.
Yes, ma'am.
Your Lordship, yes, my learned friend have already submitted. There are two writ petition that was laid before this honorable court, and it was disposed of by the common judgment and order.
Common judgment?
Yes. Now the contention is that, yes, we have already complied the other one writ petition. Now we do not comply this instant writ petition because we feel that there is a different factual situation, and now we have filed an appeal which is registered as
A writ appeal?
a writ appeal 17 of 2025, but since there is a delay in filing the appeal, IA is registered as 230 of 2025, wherein notice is already issued, and then we have already taken steps upon the petition.
On the delay condonation matter?
Yes, on the delay condemnations. Now, in this instant contempt case, I am yet to file the show cause reply affidavit on behalf of the state respondents, which
You are
is almost
representing,
ready.
which are the respondents?
All the respondents.
all of them, that's
Yes.
okay.
So if I may be given time to file my show cause reply affidavit, so as to be clear on the subject matter.
Okay, what do you say?
My lord, as submitted by my learned friend, my lord.
That,
At this stage,
how many, in this contempt petition, how many?
34 of them, my lord.
34
petitioners.
petitioners are
Yes,
there.
my lord.
And the writ petition, where is the order of the High Court?
It's from page number 14, my lord, 14.
In the writ petition, page number
In the-
40.
Yeah, 14 or what?
Okay.
Para 18 is the relevant operative person. And the state respondents have implemented, granted the benefits of this notification and corrigendum in various previous cases, as per the direction of this honorable court, which have been complied with from time to time, without any objection, my lord.
Of course, they are filing a appeal, of course.
They may have filed the appeal, but as of now, there is no appeal due to the
Yes,
delay,
that-
which is not yet condoned.
That takes the matters on a slightly different trajectory, but the thing is that since there's a direction to consider, so in this writ petition, on this disposed of order, you could have taken a clarification if you have doubts, if you say that they are on a different fact. So to that extent, the state's contention may be that this order is erroneous because the facts are different. with
That is
regard
why
to
we
this.
have a file.
So that is why the appeal has been filed, right? So anyway, but as long as the order stands, it has to be complied. But let's see then.
My lord, I would like to place one authority of the Supreme Court.
Your Lordship, I
In this
have to
regard, my
be given a chance to file my show cause reply affidavit.
This
Because
contempt
we
petition
cannot
was
have the-
filed on March 2025, my lord. Now, after even 1 year,
give you the time.
they have not filed any affidavit yet.
Heard, stop. By judgment and order dated 6/5/2025, passed by this, 24, sorry, passed by this court in WPC number 64 of 2023, along with WPC number 52 of 2022. This court was pleased to hold that the petitioners will be entitled to counting of their past services rendered prior to the regular appointment in terms of the notifications dated 19/7/2013 and 2/7/2014. The relevant para 18 of the judgment may be reproduced herein below. Full stop. The learned counsel drawing attention to, and I'll narrate a bit that will help for future subsequent dates also. The learned counsel drawing attention to a notification dated 4/12/2024 submits that 10 persons who were amongst the writ petitioners amongst the writ petitioners have been granted the relief in compliance with the judgment dated 6/5/2024, passed in WPC 52 of 2022, along with the other connected writ petition. It is submitted that, however, the relief directed by the order of this court in the writ petition with regard to the present 34 petitioners has not been complied with, dash, due to which the petitioners have preferred this contempt proceeding. Learned counsel appearing for the respondents 6 submits that the case of the present petitioners might be on somewhat different factual matrix, and in this regard, a writ appeal has also been filed against the order, judgment and order passed in the writ petition with regard to the present petitioners, but that as there is a delay, an IA has been registered upon which notice has been issued. Full stop. However, it is further submitted by the learned counsel that that they would like to file a counter in this contempt petition as well, and seek some time for the same. The prayer is allowed. You filed, how much you said, 2 weeks or 3 weeks?
2 weeks, Your Lordship.
As a small other submission, my lord. As of now, there is no stay in the appeal due to the condonation of delay not yet condoned. And the Supreme Court had held that in case of simultaneous pendency of contempt proceeding and appeal, the contempt has to be disposed of first.
Is it?
So, my lord, yes, I would like to place one authority, my lord. The case of Dr. H. Puninder Singh and others versus K.K. Sethi. May I read?
The division bench has to dispose of, you said. The division bench held, it was pending before the division bench.
That appeal was, in this case,
Or this has to be placed before the division bench.
no, my lord. That in that appeal there is no stay. That means there are no appeal at this, no stay or appeal at this stage. So this contempt has to be proceed.
Let me read the facts then.
So
In our view, in the order passed, it was not stayed by the division bench, the contempt petitions. Okay, that's the head note, more than the head notes, the narration in the para is more clear. That first you dispose of, there was a direction. You
This
Yes,
is first,
Your
to
Lordship,
first,
no
to first comply
impediment.
with the judgment.
No impediment caused because, yes, the contempt proceedings, now it's proceeding. Because, Your Lordship,
And even
it's not
after
closed
lapse of 1
unless
year,
there
they
is
have
an
not filed
order
a
for,
definitive date.
order directing for the case to be closed. Then it's still processing, so no impediment caused.
And
Simple as that.
in any case, since there is an issue of delay, that has to be, let them file their counter.
Yes.
Let them make their stand clear.
I have
And
filed
why-
this
and
contempt
why
petition
they
back
think-
on March 2025. They have been seeking time till date, my
No,
lord.
no, please,
No
ma'am,
affidavit has been
file
filed
it,
till
please.
date.
You file it, because obviously, so they were the writ petitioners had come together. So they got a relief, and there is compliance. They will be obviously aggrieved from looking at it from their point of view.
Yes.
So whatever the stand, why you think the factual metrics are different, that needs to be. And any case, see, like in vice versa, whenever the writ appeal is pending, that fact has to be brought to the notice of the contempt, in the contempt proceeding, and vice versa. There also it has to be told.
Yes.
But, my lord, in the present case, my lord, this is not the first judgment regarding this pertaining the same issue, my lord. This order writ petition was disposed of on the basis of various precedents rendered by this honorable court.
Okay, if necessary, we'll dispose it off, and but it is not a complete, subject to correction.
Dispose it off in the sense to comply with the direction as it is.
There was no iron cast principle was laid down in a sense. I think this was directed in the facts of this case. So I don't know, there may be a principle also like this, but appears to me that it was passed in the facts of this case. But this is important for you. I am keeping it in the file. After 2 weeks?
Date may be fixed, my lord. Date may be fixed. Date.
Yes, I'll give a date if necessary. can always take a date.
12th, if possible, my lord.
You can work out a date, actually. You can suggest a date to me. Today is 24th, right?
Today is 25th, my lord.
11th or 12th March? Okay. 11th.
Thee will oblige.
11-3.
Item number 5.
It's taking time, not today. Very slow.
My lord, I am appearing for the respondents in the contempt petition.
Okay.
The matter in fact has been wrongly listed. It ought to have been listed for orders.
Okay.
And this has been listed pursuant to the order dated 14/11/2025 passed in the contempt petition.
13-11.
14/11.
I'll just have a look. Huh?
Lordship.
Okay.
The contempt petition was directed for non-implementation of the judgment and order dated 24/10/2024, passed in writ appeal number 10 of 2024. Thereafter, we had preferred and review application that was also dismissed, and thereafter SLP was moved before the Honorable Apex Court. So, the my lord, initially that my lord, IA number 194 was my lord, filed. Praying for suspension of the proceeding till the outcome of till consideration of the interim prayer by the Supreme Court. And subsequently, the order my lord, has been passed on 7/11/2025. And that has been my lord, placed on record by the additional affidavit dated 13/11/2025. Additional affidavit dated 13/11/25 and page 10. And by this order, Honorable Apex Court has stayed the operation of the judgment and order dated 24/10/2024.
What was the matter arising out of? Compensation.
Lordship, compensation.
Highways Act.
National Highway Act, NH Act.
Deposited. Someone.
In fact, there was a my lord, draft award, but it was not approved by the central government. So the final award was passed, but the writ petitioners claimed that the initial draft award is the final award. So therefore, the compensation has to be paid according to the first award.
There would
That was
be
the
para 4 in the state. There would be interim stay of the impugn order, subject to respondents being permitted to withdraw the aforesaid amount.
Lordship. That
And as per the order dated 14/11, this was
14/11 because
This
to
was to be
apprise
kept
the
in abeyance.
Honorable Court.
this was to be kept
Yes.
in abeyance.
That is in the IA my lord 194 my lord. Same day my lord 14/11/25 order has been passed in IA number 194/25, keeping it in abeyance my lord, the proceeding.
Okay, ma'am.
So my lord, this 14/11/25 order my lord, in the contempt proceeding, it has been my lord, only to apprise the court the subsequent what happened to the my lord, the further my lord,
SLP.
the SLP. So I prayed that matter may be fixed again after 8 weeks or so my lord, to apprise the court. If any development comes, we may.
In the meantime,
apprise them.
it has been admitted. The matter has been.
No, my lord, it is not yet admitted because it has already been stayed. So no further my lord, order can be passed. And the proceeding has already been kept in abeyance by order dated 14/11/25 passed in IA number 194. Today was fixed only to apprise the course if any further development taken place. And in fact, initially it was a diary number. Now the SLP has been registered.
Yes.
Right.
Okay, I'll take down that number in the order. Okay, ma'am, what is? You are appearing on behalf of Learned Senior Counsel,
Yes, ma'am.
Mr.
Yes,
Malhotra?
my lord.
Yes. So we fix it after some time?
No objection, my lord.
You'd be at liberty to withdraw the amount, which has been allowed. Permitted to withdraw the sum.
My lord, I have to receive instructions from my senior friends.
Okay. Okay. We'll fix it after the Learned Senior Counsel on the other side is seeking to.
My lord, no objection to the date proposed.
Yeah. 8 weeks.
My lord.
No problem.
Only a date may kindly
I
fix so that.
can fix it. You are Mr. Borderley,
My lord, I'm assisting the Learned Senior Counsel.
Senior Counsel.
Yes.
No issues. Okay.
I'm PJ Singh.
Okay. Yeah. Ma'am, your good name?
Balit Hamwani.
Learned Counsel, appearing on behalf of the leading counsel, Learned Senior Counsel, A.R. Malhotra, on behalf of the petitioners, full stop. Heard Learned Senior Counsel P.J. Sakia appearing through online mode from Guwahati. Assisted
Tilan Zakima,
physically in this court by
Tilan Zakima.
Learned Counsel. Full stop. Attention has been drawn by Mr. Saikia, Learned Senior Counsel, to order dated 14/11/2025 passed by this court, whereby an additional affidavit was filed, wherein it is stated that by an additional affidavit, order dated 7/11/25 passed by the Honorable Supreme Court in SLP diary number 61030 of 25 was brought on record, and by the said order passed by the Honorable Apex Court, order dated 24/10/2024, passed by this court, passed by
the division bench. of
Division
the-
bench.
Right.
passed
Aizal
by
bench.
the division
Got
bench,
it.
was kept in abeyance, subject to the respondents being permitted to withdraw the sum deposited by deposited before the competent authority. Full stop. Full stop. The matter was therefore directed to be listed for appraising the court about the status of the SLP. It is submitted that in the meantime, the SLP has been registered as SLP number
032936
032936 of 2020.
dash 032937 oblique 2025.
Dash 03
032936 dash 032937 of 2025.
25. Full stop. List the matter after 8 weeks
My lord.
Gotcha.
for further appraisal of the court regarding the status of the SLP. Like this? Keep it like that. You can suggest a date after 8 weeks. 8 weeks I will have to calculate.
27th of April. 27th of April.
Your sir will be there?
My lord.
No problem.
27th of April.
27/4.
Right.
List on 27/4/2026.
Obliged.
Item 6.
Okay. No issues.
May I please, Your Lordship, an order dated 19/1/2026 has been passed by this Honorable Court admitting the appeal and calling for the TCR. However, the same has not been properly incorporated in the records. So, if Your Lordship may direct that the order dated 19/1/2026 may be incorporated in the records and call for the TCR.
Yes. It has come. TCR has come.
No, my Lord,
Let
it
me
has
see
not
the-
been called for since the
let
order
me-
dated
let-
19/1/2026.
Let me go through this order. I see. Yes, now I can appreciate it better.
Yes, yes. So the order dated 19/1/2026 may be incorporated in the records and the TCR may be called for, my lord.
You have received copies?
Not yet, my lord.
Okay. You are appearing for the,
Regarding the RF, we have received the copies, my lord.
you have received the copies? You are representing all the opposite parties?
Private respondent, my lord.
Private respondent. Only one respondent, my
That
lord.
means there were two wills. There was a will and then there was another
One
by the
res-
father.
Only one respondent.
There was one will
Anyway,
Yes, yes,
come
yes.
to that later.
executed by the grandfather and the
The
one will respondent.
sole respondent is represented by land council, who submits that copies of the appeal have been received. Full stop. TCR was called for, but not yet received.
Yes.
Issue reminder for the TCR of probate case number 16.
Yes, my lord.
16 of 2024 from the Court of the Learned Civil Judge Senior Division 5, Aizawl. We can call for the original copy,
Yes, my lord.
original TCR. Has the matter been admitted? No.
Matter has been admitted, but it has not been incorporated in the records, my lord. The order was somehow not
Yes, yes. The
incorporated
white
in the
order
records.
dated 19/1/2026, the appeal has already been admitted. Full stop. This is the matter in the orders column.
Yes,
Right? Orders column after say, 3 weeks.
3 weeks.
4 weeks.
4 weeks, my lord.
4 weeks on a date to be fixed by the registrar.
Obliged, my lord.
Item 7.
My lord, we already complied with the court order. May it please your lordship?
It has been complied with.
Yes, my lord.
The petitioners herein, as a short order, the petitioners herein had filed a writ petition being registered as writ WPC 61 of 2023, primarily with the grievance of not being granted the rental compensation for their land which was occupied by security forces since security forces in Mizoram, security forces under the Ministry of Defence, Government of India since 1996. Full stop. The writ petition was disposed of by the judgment and order dated 16/11/2026. Directing the authorities to grant the rental compensation to the petitioner. Full stop. And the exercise was to be carried out within a period of 6 months. Full stop. Whereafter, interest at the rate of 3% per annum was directed. Full stop. The said order was taken up in appeal filed WA 7 of 2024, which came to be dismissed by the order dated 22/1/2025. Agreed by the non-compliance, the contempt petition was filed. Full stop. You are representing all the
I am representing respondent number 6 and 7.
6 and 7.
I am-
But the main was Madam's.
Yes, for respondent number 1, Ministry of Defense.
6 and 7, Madam representing respond number 1, 2, 5, and Council for 6 and 7. It is submitted on behalf of the respond number 1 to 5 that the order has already been complied with in the meantime. Ms. Valentin also confirms that the order, impugn order, not the impugn order, the order which is subject matter of the contempt petition has been complied with. So I think we can close it then,
My lord, yes.
in the given facts and circumstances. Full stop. As the order it is true, it is a settled position of law that contempt jurisdiction after being admitted is primarily an issue between the court and the alleged contemptor, and that the contempt jurisdiction is not a mode of execution of the court's orders, full stop. However, in the instant case, as the order in question passed by this court and which had attained finality, dash has already been complied with by way of payment of rental compensation to the petitioners, and the petitioners also do not have any grievances left, dash. Therefore, it would be just and fair to close this contempt proceeding as well. In such view of the matter, the instant contempt proceeding is closed and disposed of in the appropriate terms. It is an indirectly method of execution. I have heard district court litigants in district court, especially in civil cases, saying that wish there was something here also. But actually, civil courts also can refer for civil contempt if the orders are not complied. But they have execution, so therefore that is not taken recourse to. Anyway, next matter.
Item 8.
My lord, in item 8, I'm for respondent number 1 to 4. We already sanctioned the money. If I may permit it to place my instruction, my lord.
You are for respond number 4, right? 1 to 4. Five, 6, 7 are they are necessary? Who's representing them? Yes.
My lord, regarding the respondent number 7, the deputy commissioner had already made an assessment over the assessment of rental amount.
This is also rental.
Yes. I have annexed at page number 31, annex 7.
Just a minute. Let me
Yes.
read this order which has been placed. With due respect. It is already in process, according to this.
Yes, my lord.
The amount has also been released. It's a matter of time, I think, before they
Yes,
get it.
my
Now
lord.
I'll come to the document you wanted to show me. Yes.
My lord, yes, if I may take your lordship to page number 31, 31 of the contempt petition, annex 7, the deputy commissioner, the respondent number 7 on his part, had communicated this assessment of rental charges.
9/4/25 or
Yes,
Yeah.
yes, 9/4/25.
DC Aizol to
Yes.
Defense Estates Officer, right?
Yes, and the authentication of the passes of the petitioners, that has also been done by the respondent number 7. This is at page number 35. So the respondent number 7 on his part had done his part, my lord.
So
And my lord, however, my lord, if I may take your lordship to page number 21, paragraph number 15. page number 21, paragraph 15, the judgment and order says that if the rental compensation has not been paid to the petitioners within four months from the date of the issuance of the order, then an interest at the prevailing bank rate.
Page,
Page number 21.
last part of the writ order.
Yes, page, para 15. It basically says that if no payment is made within 4 months from date of the judgment and order, that is 4/04/03/2025, that bank interest will accrue. However, my lord, as per the instructions presented today by by my learned friend, this bank interest has not been calculated.
No. So this is a positive development. We'll keep it pending.
My lord.
The contempt petition will keep it pending. You can take an instruction or you can file another communication,
Yes, my lord.
regarding the payment of interest. Because since the order stands,
My lord.
so I think they are liable in law to pay the same as well.
My lord. My lord.
Because the period is long over.
Yes. Yes.
Sometimes these things do take their time, the processes that I understand, but still, as the order had directed. So, this was per annum, no? Bank rate. So what would be the rate?
At the
6%.
relevant bank rate.
Bank rate is, fixed deposit is 7.5%. The bank rate is the lending, the rates at which the banks, one of the rate is the rate at which banks borrow from RBI, central bank. Is that called bank rate? Or otherwise the interest is 6%, for fixed deposit is 7.5%, that's the thing.
My lord.
Better to quantify specific.
Yes.
Anyway. Ms. Jairam Sankui, Learned Counsel for the Union of India, representing respondent number 1 to
3 and 4.
1 to 5. 1 to 5.
4, 1 to 4.
1 to 4 submits a communication dated 24/2/2026 addressed to her by the Assistant Defence Estates Officer, Guwahati Circle, about steps taken for compliance with the order. And I find that the amount of rupees 70,58,706 has already been sanctioned, and it is in process of being sent to the DC Aizawl through the State Bank of India. Full stop. The Learned Counsel for the petitioner has also drawn attention to a communication dated 9/4/2025 from the DC Aizawl to the Defence Estates Officer, Guwahati Circle, about the assessment of rental compensation sought for by the petitioner and quantifying the same at rupees 70,58,706. However, the Learned Counsel for the petitioner draws attention to para 15 of the judgment dated
04/03/2025.
25. Passed in WPC number 86
of
of
2023.
2023. The said para may be reproduced herein below. Para, page 21. No? You reflected. Or we can just write also. Directing payment of interest at the rate of at bank rate per annum for the period beyond 4 months from the date of receipt of certified copy of the judgment. Are you sure that this amount is not inclusive of interest?
No, ma'am.
Not
Yes,
inclusive.
ma'am.
In this backdrop, the Learned Counsel submits that the amount, the amount indicated in the letter of the DC, as well as in the communication submitted by the Learned Counsel for the Union, doesn't contain the interest amount. So you look into that aspect
Yes,
also.
my lord.
the respondent side may look into the aspect of the interest payment as it was directed in para 15 of the judgment passed in the writ petition. List the matter after. You can also make a calculation of the interest amount and
My lord.
give it to them.
My lord.
They can see. It will be a huge amount or little less. If it's not so huge amount, they'll be more happy. But anyway, it's looks apart. List the matter after. 3 weeks,
After
4
3
weeks,
weeks,
3 weeks.
2 weeks, my lord. Deeply obliged.
Oblige.
Item 9.
My lord, in item number 10, I'm yet to file my affidavit in opposition.
You are
My
for
lord-
state response?
Yes, my lord. If I may be granted some more time.
No objection, my lord.
Sir is also outstation, right? He's not
Yes.
available,
It's
outstation.
not
My
available.
lord.
Heard, so and so. Full stop. Quite a few petitioners. You are representing all the
All the
respondents.
respondents.
Seeks some time to file the affidavit in opposition. Full stop. Prayer is allowed. This is the matter after.
3 weeks, my lord.
This is the matter on 3 weeks, on a date to be fixed by registry. Okay.
Obliged.
Item 11.
My lord, I am for respondent number 6 and 7. I may be granted another 3 weeks' time for obtaining instruction and filing affidavit.
Pension matter, right?
My
Yes,
lord.
pension matter. Ms. Linda, you are appearing for
Respondent number 1 to 5.
6 and 7. You file a counter?
Not yet, my lord.
Not yet. You'll also
I
like
will be filing.
Second time only, my lord.
and the uncommon advocate representing 1 to 5 and also madam representing 6 and 7 seek some time to file the affidavit in the opposition. File the affidavits, full stop. The prayer is allowed. List the matter after. How much time would you seek?
3 weeks, maybe.
3 weeks? Okay. List the matter after 3 weeks on a date to be fixed by the registry.
Obliged.
Item 12.
After this, I'll take a break before all this.
My lord, this matter is pertaining to the date of birth, correction of date of birth.
Date of birth.
Yes, so, your lordship, if it is possible to make an attempt for disposal of the matter, because due to the reason that I, being the writ petitioner, I have been directed to leave my service this 28th of February, my lord.
Okay.
This is not a complicated matter, your lordship.
We can make an attempt. You are for the?
2 to 4, my lord.
Respondents 2 to 4 are the main respondents. They are the authorities of the Mizoram Cooperative Apex Bank Limited.
2 to 4.
Yes.
2 to 4. And state you are there. Pleadings have been filed? Pleadings? Not yet. Oh, you're not filed. What about you?
We have submitted, my lord.
You have
And
also-
my other friend also submitted his reply.
Rejoinder.
These all pleadings are complete.
Yes, my lord.
We can make an attempt.
Yes, my lord. May I start, my lord?
See, after some time. Otherwise, you are, as per the present date of birth, you are retiring this month.
This month only, my lord. And my correct date of birth, as by my correct date of birth, according to me, my lord, 2028.
Okay.
Yes, my lord, this writ petition is directed against the impugned letter issued by the Chief Executive Officer of the Apex Bank, wherein it was directed that the date of birth which was already rectified in my service book as per the approval of the respondent number 2, that is the CEO of the Apex Bank. It was not accepted. There later, on the verge of this was issued on 3rd of November 2025. By the impugned letter, I had been informed that my date of birth, which is to be accepted, is 24/2/1966, and therefore I have to retire in the month of February 2026. However, my lord, that communication letter was given to me despite the fact that my date of birth, as per my request, it had already been rectified. Way back in the year 16, sorry, my lord, 15th April 2016. And
earlier rectified in 2016
yes,
as
24/2/1968.
1968.
Initial,
So going by that, you will retire after 2 years.
yes,
In February, end of February 2028.
28. So, my lord, that is the
Which is
only
the
reason.
impugned order given?
Impugned order is at page
I just marked
page
tag it
14, my lord, 14. 15 is the, sorry, 64, my lord.
64?
64. 65 is the English translation.
Let us see that once, okay?
Yes.
Because that is the grievance started
Yes,
from there,
yes.
huh?
The grievance started from here, my lord. Do I need to read this, my lord? Or I'll come point by point, your lordship.
Okay.
The sequence of events.
Yes, yes. List from the,
Yes.
kind of list of dates.
I'll make a submission as brief as possible, my lord.
No.
The first point is that I joined my service in the Apex Bank, there is MCAB Limited in short form, my lord, Mizoram Cooperative Apex Bank Limited, in the year 1991. And page 21 is my appointment letter. I have annexed the retyped copy also. I joined my service as clerk cum cashier, my lord, in 1991. And at that time, my date of birth was wrongly written as 24/2/1966. And my lord, I didn't know about that. Said thereafter, my lord, I had been promoted to the junior management grade and thereafter middle management grade. And I'll not come to that. Thereafter, your lordship.
After your appointment, in the service book, it was recorded initially as 24/2/1966.
1966 in my service book. And thereafter, I had been promoted to 2 stages, and that may not be relevant for the present matter, my lord. Then thereafter, when I came to know about the incorrect recording of my date of birth, I approached the concerned authorities, and page 26 is the reply letter given to me after approaching the concerned authorities. My lord, may I read this short? This is in English translation.
No problem.
Page 26.
Yes, you can. Let us read it.
Yes, I have been addressed here. Subject regarding your application for correction of date of birth. Dear sir, in all the documents and declarations submitted by you and kept in our records, your date of birth is recorded as 24/2/1966. If we make any corrections solely on the basis of your baptismal certificate and birth certificate, the same will not be consistent with the documents presently available with us. Therefore, you are advised to first resolve the issue regarding your date of birth before the appropriate court of law. Thereafter, you may submit the court's order for making necessary correction in our records. Despite this, your lordship, what had happened was that I again approached the concerned authorities. That is what I have mentioned clearly in my writ petition as well, and asking them if I may submit an affidavit along with all the required documents, requisite documents showing my correct date of birth, my case may kindly be reconsidered, even without approaching the court of law. Then I was asked verbally, I was allowed to submit the affidavit along with the requisite documents. There is the next page, my lord. Page 27 is the affidavit. And I may not read the whole contents, my lord. So what I have stated here is that under oath, I have stated that it is as per my educational documents that my correct date of birth is 24/2/1968 instead of 1966. And my lord, page 29 is my birth certificate. I submitted my birth certificate also, which shows that my date of birth is 24/2/1968 in the middle of the page, my lord. And another document is, my lord, my baptismal certificate. There is page 30, annexure 6. The third line, my lord, my date of birth was also shown as 1968.
Okay, in annexer?
In annexes, page 30, baptismal
Next
certificate, my
one.
lord. Page 30. This is in Mizo vernacular. I have annexed the English translation. 1968 is given, my lord. And then my affidavit was considered by the concerned authorities by routing through the file to the higher authorities, my lord. Page 32 is the note sheet. And this, since this is Mizo vernacular, I'll come to the English translation, my lord. Page 34. I obtained a copy of this note sheet.
Page 34?
34 is the English translation.
Just hold on. All right.
I may read, Your Lordship, this.
Yes,
This will be relevant.
We can read.
The Chief Manager, New Market, has forwarded Sri C. Lian Luna, AG2's request to alter his date of birth, that is 24/2/1966, written in his service book, as in HSLC flagged A for reference, to be corrected as 24/2/1968, as written in his baptismal certificate and birth certificate issued by the Government of Mizoram Economic and Statistics Department. Baptismal certificate and birth certificate are flagged B and C. I am placing this for consideration regarding the application made by Sri Lian Luna, AG2. And for information so and so, and the next line, Your Lordship, the next sentence, while Sri Lian Luna was posted at our bank, the educational certificate he submitted showed his birth year as 1966. His service record was prepared on that basis. Also, in every declaration made by him, his birth year is written as 1966. In his newly submitted baptismal certificate, however, his birth year is clearly shown as 1968, which appears to be correct. However, correcting his birth year on that basis alone would create inconsistency with the other documents in our records. Therefore, I believe this issue will be properly resolved if Sri Lian Luna takes it to the court and obtains an order directing that all his other certificates should also be corrected. It would be better if this matter is resolved by Sri Lian Luna himself rather than being handled solely at our end. It seems that the baptismal certificate alone cannot be accepted. For your information and acceptance, please. And it was referred to the CEO. The next page, my lord. The next page. I'll come to the body of the, in the middle of the line, my lord. It starts with, we have received the application. Page 35.
Your application to correct your date of birth, that was dated, your application.
In the application, my lord, I have not annexed since I could not
gather it.
Yes.
But it was dated, and you know
the communication was page 26, my lord.
Okay.
Page 26. That was
Oh,
21st December 20.
So it was in 2015, probably.
2015, yes. It was in 2015.
All right.
And I'll come to page 35, my lord. And thereafter again, as I had been informed to submit the affidavit, my lord, after approaching again the concerned authorities. I'll start reading from here, my lord, the second paragraph. We have received the application. Has your lordship got it, my lord?
Yes.
We have received the application for correction of Sri C. Lianhuna, AG2, New Market Branch, date of birth from the branch manager, New Market Branch. I am putting this up for necessary action. And DGM's note is like this. Sri C. Lianhuna, AG2, was directed to resolve the issue of his date of birth at the court and thereafter to submit the court's order. He has submitted an affidavit acknowledged by the Chief Judicial Magistrate. And I am putting this up for necessary action. And this one is relevant. It appears that the necessary documents have been submitted by him. Therefore, I am of the view that his date of birth may now be corrected. I am putting this up for your approval. File was put up by the DGM, my lord, and the CEO says that it is approved. The Chief Executive Officer approved it. And thereafter, my lord, on 15th April, the last note, page 35, my lord.
Last note.
The last note goes like this. His date of birth has been corrected in his service book.
Service book. 15/4.
15/4.
2015.
Yes, my lord. So the next page is my service book, my lord, page 36. First, I may show your lordship this particular page. This is my service book wherein this particular page, my date of birth was corrected. My lord, page 36, starting from serial number 1, 1, 2, 3, 4, 5, 6, 7. I think this could be, this is legible. 24 to 1968. I have also annexed the retyped copy, my lord. First, I want to show your lordship this one.
Corrected by so and so.
Yes, corrected as per so and so, affidavit dated so and so. The page 41 is the, my lord, 41 is the retyped copy. Serial number 6, my lord. 24 to 66, it was struck out and it was corrected with 24 to 1968. Corrected as the affidavit duly signed before the judicial magistrate so and so. This is what the note sheet shows, my lord. And that happened in the year 15/1/2016, my lord. In the year 2016, the correction.
The correction in the service book.
In my service book, my lord.
15/1.
Sorry, my lord, 15/4/2016.
15/4/2000?
Yes, 16.
16.
16. And that was done, my lord. So it had attained finality and no other communication or no revocation of that rectification of my date of birth happened thereafter. So I have been serving
since 2016.
Since 2016. No other subsequent order or revocation was passed by the concerned bank, my lord, the respondents. However, now the problem started in the year 2025, towards the end of the year 2025 only, when I had been verbally informed that the official, that some of the records maintained by the, I had been informed that there is a rumor that I have to retire from my service in the month of February 2026. So thereafter I submitted knowing about that, I submitted my representation to the Chief Executive Officer. That is page 48, my lord.
Okay.
My lord, if we look at the subject of this letter, it is also stated clearly that application for pension as per correct date of birth. Because I had a rumor, I knew the rumor that I was about to
retire.
Yes, retire as per the department's concerned authorities' direction in the month of February 2026. So I had explained everything, saying that my correct date of birth is so and so, 19, instead of 1966, it should be 1968, and it was already corrected also, my lord. Then page 49, my lord, I have annexed all these, annexed again all these documents. Page 49, documents enclosed. To cut short my submission, my lord, I think it may not be necessary to read all the contents.
I'm
That's why-
just going through it.
Yes, that's why I'm not reading.
Okay, so thereafter, what happened?
Thereafter, my lord, page 49, I have enclosed all these required documents as well, my lord. Even in my representation, which was submitted on 4th September 2025. And my lord, page 50.
Page 50.
50 is my Aadhaar card. It shows my date of birth as 1968, 24/2/1968. And 51, my lord. 51, my testimonial, pre-university. It also shows again 68. And my lord, my electoral photo identity card, 52, also shows 1968. And page 53, my PAN card also, my lord. And my birth certificate is at page 55. And my baptismal certificate, I have shown it to your lordship, page 56, my lord.
Right.
And your lordship, page 61 is my primary school leaving certificate examination. This also shows 1968, page 61, my lord.
This was 1966 was recorded on the basis of your matric certificate when you joined service.
Joint service, yes, my lord. It was wrongly written.
Wrongly
recorded.
written on the basis of?
Without, it appears that without any basis, my lord. Because all this certificate shows that, the document shows that my date of birth was 68.
Okay.
And after submitting that my representation in the month of, my lord, this September 2025, I was replied with this impugned letter.
3rd November.
Yes, page 65.
Okay.
3rd November.
Let us read this.
Yes, my lord. To Sri Lian Luna, JMG to Dorpui branch. Dear sir, alteration of date of birth regarding. We have received your letter dated 4th September 2025 regarding service retirement, and we deeply regret the hardships you mentioned. However, for the following reasons, you are hereby informed that your application could not be accepted. Your date of birth at the time you initially joined our bank, on which you placed your signature and which was accordingly accepted by the bank, was 24/2/1966. Your first application for alteration of your date of birth was forwarded by the Chief Manager, New Market Branch on 12/2/2015, vice so and so, dated 12/2/2015, and this was 24 years after your joining. In our bank, alteration of date of birth in the service record is done in accordance with the Mizoram government rules as per SSR 2024. This is staff service rules of the Apex Bank, my lord. Number 108. As per this, your application regarding your date of birth was submitted after 5 years of joining your service. And since there appears to be no bona fide mistake, your date of birth could not be altered. So this is the impugned order. However, your lordship, before coming to the other points, I may take your lordship to page 66. these are the documents issued by the Apex Bank authorities. This is the sanction of staff housing loan, my lord. Here, it was addressed to the chief branch manager by the chief executive officer. It was the bottom of the page, my lord, terms of repayment. I see, I hope your lords got this, page 66.
Yes.
Regarding this loan, terms of repayment, 72 months, my lord. It is mentioned here at the bottom of the page, my lord. This means 72 months will be 6 years, starting from 2022.
28.
So it is in compromise with the correct date of birth, my correct date of birth. As per my correct date of birth, I have to retire in the year 2028 only. And now in consonance with this, page 68, this is a part of this letter, the annexure. Page 68, my lord. The first serial number 1, it says that date of superannuation of the applicant, 24/2/2028.
What is this form?
This form is, it is accompanied, this accompanies the annexure 12, that is page 66. It comes along with page 66, my lord. Loan. And it was clearly mentioned by the chief executive officer also, saying that my superannuation date will be 24/2/2028. And my lord, other point is page 73. Page 73 is the festival advance, which were given to the some of the employees, and it was released on 27 November 2025.
Your name figures at serial number?
Yes, serial number, that is at page 75, serial number 70. And let me go back to page 73, my lord. Page 73, the second paragraph says, my lord, recovery of the festival advance so disbursed shall commence from the salary of January 2026 onwards. So it has to be repaid till October 2026. So that shows that, my lord,
one important question for this adjudication would be that on the date on which this impugn order was issued,
my lord,
what was your date of birth in the records? Because as per your contentions and the copy of the service book you showed me, it had already stood corrected.
Yes.
As 24/2/1966. So going by that, line of this thing, the date of birth in the records, the latest date of birth in the records has to be that, if it has not been changed. So I did not understand what they meant by saying, of course you will reply, that this is cannot be done.
That is what, my lord. After making correction as 1968, and that was not revoked, my lord, and no other subsequent order was passed, and even in the note sheet also nothing had been done to make any other subsequent alteration. So it is still, it has attained already, it had already attained finality, my lord, 1968, and it was corrected way back in the year 2016 as 1968. So despite this, I had been informed that no, as per the
one thing is that with the purported incorrect date of birth,
yes,
which is 24/2/1966, you had obtained 2 promotions also, 2 grades, right?
2 grades.
Promoted to 2 grades, 2
Yes.
stages, you said.
Yes.
2 stages. Anyway, subsequently you sought the correction.
Yes.
Right. Anyway, so next.
So, my lord, my other point is this, page 79. The last page.
Yes,
This is also the increment order, my lord.
Yeah, no. Yeah,
the
serial
following,
number- serial number
I am in serial number 5. My name is in serial number 5. And the last paragraph says, my lord, the probable due date for next increment will be in July 2026. So the reason why I'm pointing out all these documents is to prove the fact that, my lord, these are my date of birth as 1968 was also after making correction. It was also accepted by the
No, I
Apex
think
Bank.
this sentence is generic, I think, for all the candidates. I think.
Yes.
Anyway, probable due date for next increment
Yes.
for everyone.
Yes.
Anyway, we'll look beyond that.
So
These are the contentions.
yes, these are the contentions. My main point now is that, your lordship, after joining my service in the year 1991, and whether it is after 26 years or 24 years or whatever, it is the concerned authorities of the Apex Bank Limited who accepted my application, my request for making correction of my date of birth from the year 1966, wrongly recorded, and by replacing 1966 with 1968. That is my correct date of birth, my lord. 24 to 1968. And it was done as per the approval of the concerned authorities. And the only way to make a correction is by putting the correction, by making rectification in my service book. There is no other way, your lordship. And now, after reading the affidavit in opposition of the respondents, what they stated is that it is only a mere noting, which is recorded in the note sheet. But, your lordship, they say that as per the contention of the
No, the
respondent
service book entries are countersigned. The counter signature of the head of the office is taken.
is there. So, my lord,
I know that. Because
yes, what they have stated, contended is that, your lordship, separate administrative order is to be issued. But that is not so, your lordship.
Ideally, yes.
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 So,
administrative order should have been issued or should be issued. Anyway, come to that.
yes. So, my lord, now, the reason why I'm pointing out is that in respect of the correction of the date of birth, your lordship, now the only procedure to be followed is by making a correction itself in the service record, my service book, my lord. So that was done as per the approval. Approval is given here.
Is the original service book here?
No, my lord. It's not been called. But
No.
I next in my...
Not been called. Anyway, let us see. We'll try to manage with whatever we have.
So, my lord, what they have stated is that it was a mistake. The approval given by the CEO, the head of the office, it was a mistake. And another mistake was the putting up of the file by the deputy manager proposing correction of date of birth. And they have contended that since there is no court order, only affidavit cannot do it. But affidavit was also accepted along with all the accompanied documents which shows my correct date of birth. On the basis of that, it was approved. And it was manifested by making a physical correction, striking out the wrong one and giving the correct one in my service book. So, my lord, now they cannot blow hot and cold at the same time. This is my other ground, your lordship. And another point is that what the respondents also stated is that now since they don't have any particular provision for correction of date of birth in the staff service rules, they are following the state government, rules of the state government, Mizoram state government. And so it has, and by conjoint reading with FR 56, note 6 of FR 66, Fundamental Rules 56, my lord, it has to be corrected within 5 years. That is what they say. And the rectification of my date of birth was after 24 years from my date of joining. But that correction was not done by me, it was done by them, by the respondents, as per my request. And it is the respondents who did the correction, my lord. So, your lordship, there is no illegality in that regard. And if we look at the Government of Mizoram notification, my lord, I have given to the bench clerk. Let me show it to your lordship, my lord. That memorandum office memorandum.
I will proceed with your argument today itself. But suppose in the course of deliberation we feel the need for the original service book. Can it be brought tomorrow?
I'll try.
Headquarters is here only.
Yes, Madam.
Headquarters. Let's keep it open.
Madam.
Okay.
Shall I continue, my lord?
This is the
office memorandum.
that rules.
Yes,
Alteration
regarding
of-
the alteration of date of birth. My lord, the relevant point is the next page, second page. My lord, second page is the memorandum dated 4th June 2012.
Yeah.
I may take your lordship to the second paragraph, my lord, second and third. It is written like this. It had also been emphasized that in that OM that all administrative departments and head of departments offices should verify the service books of employees working under them and to see if there are overwriting or alteration of date of birth in the service book, and if there is any such alteration of date of birth should be brought to DPNAR with justification within 3 months. What I'm trying to point out is this is in the service book only, my lord. Date of birth in the service book. This is the main point. And the third paragraph says, my lord, it had further been mentioned in that OM that there may be certain instances where the date of birth once recorded in the service book may be altered unauthorizedly without the knowledge of the head of departments or offices. This undesirable practice should not be allowed to occur at any quarter. To avoid this undesirable practice as well as to ensure verification of all service books, a proper register should be maintained by the heads of department officers, so and so. I'll stop here, my lord. What I'm trying to say is
So
that...
this is what I said. Such entries in the register should be signed by the head of the office.
Yes. So, your lordship...
And the date of birth of the employee so recorded in the register.
Yes,
But the same, this process was not followed according to you?
This
procedure.
This is for the government of Mizoram employees, my lord. But the Apex Bank employees are, Apex Bank is one of the cooperative society bank only. And my lord, they don't have to follow in toto. In letter, they don't have to follow it. As far as possible, this is what the staff service rule says. My lord, let me take your lordship to the affidavit in opposition filed by the respondents bank. Page 31, Annex 5, my lord. Affidavit in opposition.
This requires a full hearing only. But it's justified that we are doing it at the stage of admission because of your urgency. Because of this date.
Yes, my lord.
Because of this date. It's better we take a decision this way or that way before that date.
Yes.
So we take up the affidavit in opposition.
Yes, my lord. Now the Annex 5.
Rejoinder.
The page number is missing in my copy, my lord. So sorry to say that.
Affidavit in opposition for 2 to 4.
Yes, my lord. And if I'm not mistaken, it should be page 31, my lord. Annex 5.
Chapter
13.
Annex of, that's okay. I'm on the manual of instructions.
Yes, Rule 108, my lord.
Okay.
Rule 108. It says that where no specific provision has been made in respect of any matter in these staff service rules, the relevant rules of the state government relating to such matters shall be followed as far as possible. This is what it says, as far as possible. This is the staff service rules of the Apex Bank Limited, my lord. And since the date of birth, the issue of date of birth is not included in their staff service rules.
Can you read that again to avoid the possibility of unfortunate?
Where no specific provision, Rule 108, my lord.
Okay.
Where no specific...
108.
Yes. It merely says as far as possible, my lord.
This is from the...
This is the extract page of the staff service rules.
Staff service rules.
Staff service rules of the Apex Bank Limited.
Staff service rules. of Apex Bank.
Apex Bank.
Note 108.
The next page is also the,
There is no specific provisions in any matter. In any matter. You know.
in any matter. So what I'm trying to stress is that, my lord,
I
as
get-
far as possible only, not
as
in
far as
total.
possible, yeah.
Yes.
As far as possible.
Not in total.
And as far as the subject matter is concerned, the staff rules are silent on the question of date of
Exactly.
birth. Change,
Yes, date of
silent.
birth. Yes, my lord. It is silent on that issue.
And as per Mizoram government rules, within 5 years.
We did 5
That's
years.
it. As you know, the law of date of birth,
Yes.
service law pertaining to date of birth, changes that fag end.
Fact and
It's
that is
difficult.
what, my lord. That
Fag
is,
end is discouraged.
that is very true, your lordship.
That's a general
Yes.
principle. On those principles, these rules have been framed. That within 5 years.
Yes.
That's what I'm trying to say.
Yes. So, my lord, what I'm saying is that regarding that point, now what the respondents are saying that it has to be within 5 years, the correction should be made. But I am not the one who did the correction. The correction was made by the respondents' bank, the concerned authorities, after the expiry of 5 years. And it is stated clearly by the staff service rules, my lord, that it has to be followed as far as possible, the government rules and office memoranda. So it is not strictly, it doesn't strictly says that it has to be followed in letter, as it is, my lord.
As far as possible.
As far as possible only. So they can bend it. There is a wide power, my lord, to the respondents. So they exercise their power, authority, by rectifying my date of birth in the year 2016. Maybe it was after 24 years since my joining of service. So whatever it may be, they had rectified it in my service book. And my lord, if we look back that office memorandum,
Yeah, another question, this
Yes.
related question which comes to our mind
Yes.
for both sides actually. That firstly, that correction which was done in 2016,
my lord,
was it validly done? And if it is validly done, definitely it sustains. You know.
Yes.
If it was not validly done, then what did the authority do about it?
yes, that is what.
These are the two questions,
Two
apart from the
important
general
questions.
principles.
Exactly, my
Anyway, so you complete?
Yes, my lord.
Come back to you.
I'll
the reply.
have some more short submissions only, my lord.
Yeah, you will make it. And,
So regarding
any case law in your some favor
yes, yes.
also you can submit.
I'll produce at the end of my submission, my lord, one case law. So, my lord, the other point is that now it is not the petitioner who approaches this honorable court at the fact end of service regarding in order to change his date of birth. The reason why I'm approaching this honorable court is due to the illegal action of the respondents who are trying to alter my date of birth again at the fact end of my service. So there is the difference. So in this regard, I may produce one citation, my lord. This is 2022, volume 6 SCC. I have printed out the copy, my lord. 2022, volume 6 SCC 211.
These loan documents that you showed me,
Yes.
showed the court, those documents you are trying to show through
Yes.
those documents that the authorities also relied upon that document,
Yes.
that date of birth.
Yes.
68 document.
68, my lord. My date of superannuation. My lord, this citation, relevant portion will be starting from para 27. Page 221. Twenty-seven, 28, 29, my lord.
Para.
Para 27, 28, 29. May I start reading from para 27, my lord?
Yeah.
We find the action of the employer lacking in authority of law in this case on two counts. First, it fails for not adhering to the principles of natural justice. The decision not to follow the service book recordal was taken without giving an opportunity of hearing to the appellant. The opportunity of hearing of the appellant also accrued because the employer themselves had proceeded on the basis of that later date, that is 21/9/1949, was the birth date of the appellant, and this was a long established position. Moreover, since in these own records of the employer 2 dates were shown, under normal circumstances, it would have been incumbent on their part to undertake an exercise on application of mind to determine in which of these records the mistake had crept in. That process would also have led to involve participation of the appellant, which would have been compatible with the principles of natural justice. Para 28. There are several authorities in which this court has deprecated that the practice on the part of the employees at the fact end of their career to dispute the records pertaining to their dates of birth that would have the effect of extension of length of service, their service. We are not referring to those authorities in this judgment, as the ratio laid down on the count by this court is not relevant for adjudication of this appeal. The present matter is very similar, my lord. Page para 29, your lordship. The very reasoning on which an employee is not permitted to raise age correction plea at the fact end of his service to extend his tenure should also apply to the employer as well. This is very relevant, my lord. It should be also applied to the employer as well. It is the employer here who had proceeded on the basis of age of the appellant reflected in his service book during the latter's service tenure, and they ought not to be permitted to fall back on Form B, which would curtail the VRS benefit of the appellant. So, my lord, my point is that as per my request, I was given the opportunity, then in the year 2016, my date of birth was rectified, my lord, as 1968. As per the approval of the CEO, the top official of the Apex Bank Limited. And although, my lord, there may not be a separate administrative order also, however, it was approved by routing through all the officials, by going the file to the upper authorities also. Then it was approved. On the basis of that, correction was made, my lord. And thereafter, there is no subsequent order, revocation of my date of birth, which was corrected. And there is no other subsequent order, putting back the wrong one. No such order or any proceeding was drawn, my lord, thereafter.
Okay.
So it is the employer, that is the Apex Bank, who at the effect end of my service are trying to accept the wrong one, 1966. So this Honorable Apex Court's judgment has also to be applied, my lord, similar to the petitioner. This is what this judgment says, as your lordship also knows, my lord. So the other point is, my lord, what the respondents raised is that they have produced these certain documents in order to show that I had also the other date of birth is written. My lord, I may take your lordship to page 23 of their affidavit in opposition.
Just a minute.
Yes, my lord.
Page 23.
23 of their affidavit in opposition. This is the Group Savings Link Insurance Scheme document. What they have stated is that my date of birth here is written as 1966, my lord.
Just a minute. Page 20.
Page 23, Annex 3.
Yes. So this is what is saying, letter of admission.
Yes, this is the Group Savings Link Insurance Scheme.
Okay, this was in 94.
November 94, below that, my lord, date of birth as recorded in is 24 to 1966. This is the stand taken by them, my lord. However, if we look at the date of the letter at the right top of the page, my lord, the same page, it was written on 4/7/1994.
That's what I'm saying.
That was before the correction was made, my lord. And page 25, my lord.
This was about 3 years after you joined.
Yes.
Okay, anyway. So
page 25. This is also produced by them, my lord. Page 25, serial number 3. It again shows 1966. But this is also, my lord, before the correction.
This communication is, this document is dated.
Dated as 1997, my lord, page
27 to
26.
1997.
Yes, 26. Page 26 at the bottom of the page,
Yes,
left
got-
side,
Got it.
97. And the other one is, my lord, 26. Page 27. This is their, they are trying to
At
rely
that
on
time,
this.
you were not aware, of course, that will be a natural question.
Yes, yes.
But at that time, since somebody writing on my behalf and
Yes.
I myself acknowledging something,
Yes.
if there is a mistake,
There is a
it should come
mistake.
to my notice and I
Yes,
should
yes.
point it out. That
So-
is, of course, that is why they are saying, they are bringing these documents. They will definitely do so.
Yes. So, my lord, these are not relevant. What I'm trying to say is that because these were the before the correction of my date of birth. And it was not, there is no proof that it was written by me also. Whatever it may be, your lordship, thereafter my date of birth was corrected as 1968. So my humble submission is that, your lordship, now the impugned letter is to be set aside because it is not based on anything like any revocation of my date of birth, which was already rectified in the year 2016, and no other subsequent step had been taken by the concerned authorities of Apex Bank, my lord. And the respondents had, the only contention they raised is that there has to be other administrative orders separately to be issued by them. But that is not the point. So long as correction is made in my service book, if we look at the Government of Mizoram Office Memorandum also, my lord, it stated clearly that the correction is on the body of the service book itself. And it, as per the approval of the respondents, it was correctly done. So my prayer is that this impugned letter decision may be set aside and it may be directed that I may be go on superannuation only in the year 1968, madam. 2028, sorry.
We'll resume after lunch.
My lord, my lord.
Okay. How long? You'll take an hour or something, I think. Is it? It'll require an hour. So we can, if you agree. I'm not saying, I'm not insisting, but if the councils want, we can quickly run through the order items and finish it
Yes,
and
yes.
come back to the hearing. That
I'll
may not
take
be
about 1 hour.
bad idea. Okay.
I'll take about one hour.
Yes. That's why. Otherwise, they'll keep waiting. We'll do that and then we can.
And I may be allowed to rebut also, my lord. There.
Oh yeah, naturally. Orders, orders.
Orders, item 13.
Can you just keep it that side? Okay. Let us go through it.
My lord, we have received the paper book and the matter can be listed for hearing.
It's ready for hearing. TCR has been received.
Yes, my lord.
Ma'am, you are appearing for the other side?
Yes, Your Lordship.
Okay. Nice. It is submitted. It is submitted on behalf of the appellant that the matter is ready for hearing and may be listed accordingly. The respondents are represented by learned counsel. The original TCR has been received already. We'll fix. How do you fix it? List the matter. List the matter for hearing on a date to be fixed by registry.
Yes,
like
Your
that.
Lordship.
Item 14 to 16.
Where is the cause list? Misplaced it or something. It might be here. Give me another one. This is the daily, the weekly one. Must have gone with some file. Take out a print and give me. Give me another print. Second page onwards. These are three matters.
My lord, with respect to the respondent number 2, who is the driver of the accident vehicle, as per this honorable court's direction, we have taken steps upon the respondent number 2 by way of Dusty.
Okay.
And we have accordingly submitted affidavit. However, as per office note 2402/2026, the respondent number 2 still remains unrepresented.
That's okay.
And my lord, the respondent number 2 may be a necessary party because my learned friend, the insurance company has submitted that he was under intoxication at the time of accident.
The appeal has been filed by?
I initially, the claimant before the MACT has filed the instant appeal.
Appeal for enhancement?
Yes.
For enhancement?
Yes, for enhancement. And there are
they have filed
two cross appeals.
Cross objections?
Yes, cross objections.
Yes, owner has filed, company has filed, and claimant has also filed. Three parties.
Claimant has also filed?
Claimant in this case, my lord, this is the appeal has been filed by the claimant.
No, claimant has filed the appeal.
Objection by two.
All parties filed the appeal. Three. Owner has also filed separately, insurance company separately, and so has the claimant.
Owner also?
Yes, all of them. Three parties separately.
Nikal de. New list I'll need. No? Then this is the weekly list. Oh. So what to do? Because you think he would be necessary? The driver would be necessary?
He may be necessary because the contention of the insurance company is that...
I understand. Yes. I get it now.
As well as the finding of the trial court is that he was intoxicated. And because of that, the pay and recover was directed.
I see. You are for IFCO Tokyo?
Yes. It is in item 16. My appeal is in item 16.
Okay. Lalmohan, see that's number 2. You are representing?
I'm for respondent number 1, the claimant.
Claimant in that case is in item 15.
No, I did not have this, so 14, 15, 16.
15 is
First-
claimant,
Yeah, first I'm taking up MSC 17, the appeal.
MSC,
MSC 17.
My lord.
MSC 17, item 14.
In MSC 17, you are for the claimant, you are for respond number 3.
MSC 17,
Yes, yes.
And 1 and 2, 2 is the driver.
2 is driver.
Driver and 1 madam is appearing.
Yes.
Honor.
Right?
1 is the owner.
You just right. Current counsel appears for the appellant. Then respond number 3, insurance company, and respond number 1, full stop. Dusty service was resorted to with regard to respondent number 2/driver. But despite such service by Dusty, he has not appeared as also reflected in office note dated 24/2/2026. TCR has come? Record has come?
No, my lord.
Not sure.
TCR, item 14 is showing TCR. With TCR is there. Is there.
It's there. It's there.
The same TCR.
Yes. As for office note dated 23/1/2026, TCR of MACT case number 33 of 2023. This is the same.
Yes,
Same
matter,
TCR. For 3 items.
Scan TCR, madam, you're right. Scan TCR has been received. Actually, this kind of matters, we can get the original one also, this final disposal. Scan TCR of MACT so-and-so has already been received. So in a way, except for that issue of respond number 2, driver, this matter is ready for hearing actually. Is it?
My lord, paper book may have to be prepared now.
You want a paper book to be
Yes.
prepared? Okay. Registry may prepare a paper book in sufficient sets for the respective learned councils. Full stop. In the meantime, let it remain in the orders column for a while.
My lord.
Huh?
And my
Await,
lord,
because I don't think he will appear. That's the thing. What to do then?
Dusty has already been served.
I don't think, because they don't.
You can await for some time.
No, they will not appear. Dusty is completed.
complete.
Dusty is completed.
Dusty complete.
Completed.
My lord, if I may make one submission.
Yeah, please.
This being cross objection by both all the parties. My lord, the expense for paper book may be shared equally. My lord.
Okay. Okay, right. This is not a criminal case. So, are you agree? No problem. The cost of preparing the paper book shall be shared by the between the parties. Shared by the parties. Okay. Now, awaiting means we can await, but he will not appear. It's unlikely to appear, I think.
Unlikely, because
Unlikely,
in the trial court also,
He won't understand the
it was
implication of.
proceeded ex parte.
He may not understand the implication of that finding and his appearance before the court.
My lord, my lord.
Then what should we do? This is the matter in the orders column. After so and so, after 3 weeks,
My lord, 3 weeks.
after 3 or 4 weeks.
Paper book is also
Yes.
likely to.
Yes, after 4 weeks. So in the meantime, if he comes, which I doubt,
Yes.
because we know these trends.
Completely acknowledged.
Oh, yeah, okay. Just now I take up this cross objection. COB FA 3 of 25. Connected to MSC 17, MSC appeal 17 of 25. This cross objection has been filed by the respondent number 1 of MSC appeal 17 of 2025, and who is stated to be the owner, right?
Claimant.
Or claimant. Well, no, claimant, he is the claimant, isn't it? He's filed for enhancement. Are you not the claimant?
I am the claimant in MS Make Appeal 1725.
Yes. No, the trial proceeding is the same.
Same.
In the trial proceeding, you were
In the trial proceeding, I was the claimant.
claimant, right?
Yes.
Fine. He was the insurance company.
Yes.
And she?
The owner.
The owner of the vehicle.
Yes, my lord.
Owner of the vehicle.
Owner.
That's what I asked actually. Who was stated to be the owner of the alleged offending vehicle in the proceeding before the learned MACT in MACT case number 33 of 2023. Right? That's fine. Good stuff. The claimant and the insurance company are represented. In this case also you have to take steps, or it's covered?
My lord, this,
Driver-
this,
dri-
this is covered, my lord.
It will be covered?
Yes, covered.
Dusty service was resorted to with regard to respond number 2 was the driver. Yes, ma'am, you want to say something? No. Was the driver of the offending vehicle. But the said party has not yet appeared despite such service. The original TCR, the photo scan TCR has been received. The registry has already been directed to prepare the paper book. The cost of insufficient sets for the councils, the cost of which shall be borne by the parties. List the matter after 4 weeks in the orders column. This appeal is filed by the insurance company or
Insurance company.
on the amount, the quantum.
The pay and recover, the issue of pay and recover. Section 150 does not give any provision for pay and recover. So our contention is that it has to be on the owner. The liability has to be on the owner, not the pay and
You are agreed by the direction for pay and
Direction for
recover.
pay and recover only.
This appeal has been filed by the insurance company against the judgment and order dated, award dated 21/8/2025, passed by learned member MACT Aizol in MACT case number 33 of 2023. Right. The The respondent number 1 / claimant is represented by learned counsel so and so, and respondent number 2, owner of the vehicle, represented. And in this case, notice was returned unserved due to insufficient notice. You said it will be covered by the.
This will be covered, my lord.
That one will cover this also.
Because
this
the
is
same
a
driver.
Hmm?
The
Same
same
driver,
driver
same,
and same appeal, yes.
same driver. In MAC appeal 17 of 25,
Yes.
pursuant to order of this court, dusty service was successfully resorted to with regard to respondent number 2 driver, but despite such service, the party has not yet appeared. The rest of the thing will be same, man. Direction for paper book has already been given. Cost of which will be borne by the parties. List the matter after 4 weeks in the orders column. Let it remain in the orders column for the moment.
Yes.
But we have to proceed despite his, because I don't think he'll appear. Unlikely. Unless do you know him personally or something?
Not personally.
Yeah, her client might know. Owner, driver. So if necessary, they can appear through you also, he can appear through you also, you know, and because the owner is the only person who might know. Otherwise, you'll have to proceed. What can you do, isn't it?
Obliged.
Item 17.
I is for?
I is for Lordship, continuation of delay in the special leave petition, Lordship. And yesterday, Lordship had passed
It was
appropriate order.
Yesterday's matter?
Yes, no, not yesterday matter. It's same with yesterday one.
Same as this.
Yes, Lordship. Then this application is filed under section 4195 of the BNSS 2023. But Lordship, here in this particular case also, then we are inadvertently not invoke the section 5 of the Limitation Act.
Oh, so same.
Yes, Lordship. Same
So
order
it will
may be
say-
passed. Lordship.
I have no objection to the amendment.
So it will be similar to the order we
Yes,
passed
yes,
yesterday.
yes,
That order, is one of which requires some clarification, right? But typographically. So you just keep it like that, same as yesterday's order, pertaining to this Assistant Commissioner Customs. I'll dictate in the chamber.
It's obliged.
List the matter.
After 2 weeks, Lordship.
After 2 weeks.
Item 18.
This will be, I'll give it in the chamber.
Lordship, this IA is for condonation of delay of 54 days.
NCB is filing the appeal.
NCB is filing
revision,
criminal revision petition in Lordship.
Against
The order which
release one vehicle, Jima, you know? It was interim custody was given.
Yes, yes, yes.
Despite the issuance of freezing order by the investigation. Smugglers and Foreign Affairs Act. Okay. Who's appearing, Mr.?
None is appearing, Lordship.
John, name is shown.
No one, my lord.
Oh, no, that's your name.
Notice was already served, Lordship.
No, okay. Notice has to be seen. It's
Yes.
coming from
Correspondence is there, Lordship.
Huh?
Correspondence is there. Online tracking of the.
Okay, it's come for the first time.
Not the first time, Lordship. This is the third time, Lordship. It was notice was issued way back in November last year, Lordship.
Yes.
So it was deemed served, Lordship. In terms of the order passed by this Honorable Court on 6th of February, my lord. So I think we can proceed on.
So they are served. Notice has been served.
Already served, Lordship.
None appears.
None appears.
So we can dispose it of.
Yes, Lordship.
Okay.
So now this, Lordship, is an application under Section 5 for Limitation Act,
Yes,
Lordship,
I get
for
it.
a condonation of only 54 days, Lordship, in preferring this criminal revision petition. The facts regarding this case, Lordship, was there was a case in which 2.8 kgs of heroin was seized, my lord, and in connection with which the one vehicle, Thar, Mahindra Thar, was seized, Lordship. And to make the matter short, Lordship, that vehicle, Lordship, was freezed by competent authority, which was constituted under the NDNPS Act, Section 68F, Lordship. And despite that frozen order, Lordship, that was issued way back in 24th of March 2025, Lordship, the Learned Trial Court, my lord, of NDNPS, a special court of NDNPS, issued the impugned order, my lord, which is at page.
We'll go into that. First, let us,
My lord.
Today, let us pass the order in the IA.
Yes, yes. For that, my lord, yes. I went into the...
The
yes.
applicant petitioner is seeking to file, this is IA 51, it's only that order. The applicant petitioner is seeking to file a criminal revision agreed by order dated 25/6/2025 passed by the learned special judge and DPS Aizol in criminal misapplication 47 of 25, whereby a vehicle vehicle within bracket Mahindra Thar bearing registration number MZ04A7740, which was seized in connection with
seizure of...
what is the PS case number? NCP case number 5 of 2024 was given in interim custody to the respondent, and it is the case of the petitioner that there was a freezing order in place regarding the said vehicle, and therefore they are aggrieved by the order granting interim custody. However, there is stated to be a delay of 56 days. 50, it is written 56 days. 50?
We'll
go by 56 days.
All right.
In preferring the revision. And hence, an application under Section 5 of the Limitation Act 1963 has been filed. Just give a dash, giving rise to the instant interlocutory proceeding. Full stop. Notice was issued upon the respondent, and after perusing the postal track consignment report, this court by order dated 6/2/2026 accepted the same and held that notice has been served upon the sole respondent. However, none has appeared on behalf of the respondent. As mentioned earlier, the quantum of delay is 56 days. In terms of the Limitation Act, the period for filing a revision, the limitation period for filing a revision is 90 days. The explanation for the delay of 56 days has been narrated in para. Can you help me with that?
Para 2, Lordship. Para 2 of my petition.
Revision will lie against order of Jima. It will lie.
My Lord, yes.
Which was the para?
Para 2 of the petition.
Of your petition.
Para 2, Roman 1-2. Roman 12, Lordship. Para 2, Roman 1-12. And that para 2.
It is enumerated in para 2, Roman. Para 2 is right.
My Lord.
Para 2.
And if I may also rely on Lipok-Ao, my Lord, the judgment in Lipok-Ao also. Will that be required?
To summarize the grounds, it is stated and contended by the applicant in support of the prayer for delay condonation that, give a dash, that after Furnishing of the certified copy. The same was sent to NCP Agartala, which was put up before the assistant director, and thereafter file sent to Journal Director NCB. Subsequently, certified copy of the order was obtained by the learned special PP upon instruction of the IO, and thereafter the certified copy was handed over to the NCB Council and the High Court and the Aizawl bench of the High Court on 22/10/2025. Thereafter, the revision was drafted, vetted by the concerned higher authorities, and thereafter filed. Full stop. However, in the process, there was a delay of 56 days. Full stop. In the given facts and circumstances, upon perusing the grounds, considering the quantum of delay, I deem it fit to allow the prayer for condemnation. Accordingly, the delay of 56 days in preferring the criminal revision is hereby condoned. The IA stands allowed and disposed of.
Right, Judge.
Revision, should I pass an order today itself?
Notice may be
Yes,
issued.
notice can be issued, I think. The first part, ma'am, the first part of the earlier order will be same here. The petitioner invoking section 438 BNSS has filed his revision against order dated so and so 25/6/25 passed by. I think it will be same. The sole respondent is stated to be the owner of the vehicle, right?
Actually,
No, we cannot
not
say
the
that.
registered owner.
Huh? Yes.
The registered owner was not party
Oh, okay.
because that
We'll
was
not
wrong. That is the wrong committed by the
I'll
trial
not say.
court.
Issue notice, steps of notice may be taken upon the sole respondent.
Mine.
How will you take? Speed post. It's Champai. Speed post, you can take. Full stop. Further, call for the scanned copy of the relevant parts of the case record, including the impugn order from the court of the learned special judge NDPS, Aizawl. Release the matter after 4 weeks.
2 weeks?
3 weeks. On a date to be fixed by the registry. Okay.
Item number 19.
Obliged, Lordship.
Yes.
My pleasure, Lordship. Lordship, this is an criminal appeal against the judgment and order passed by the Chief Judicial Magistrate, Aizawl, in NI Act 138, Section 138. And it was dismissed due to non-prosecution, Your Lordship. So
You are seeking to file an appeal against acquittal?
Yes, yes, Your Lordship.
As
So,
a
Your
complainant?
Lordship, we have filed the appeal, but there is an erroneous mistake in the petition. So, High Court has directed to file, twice time it was directed by this Honorable Court to file afresh. So, this is the first time we have filed the petition, Your Lordship. There is two connected application, Your Lordship. There is a delay of, there is a petition of seeking permission from this Honorable Court as well as delay of some days in filing the instant appeal.
The IA 7 is pertaining to the leave petition.
Lordship.
We issue notice at this stage?
Lordship.
Because I don't find any previous order.
Your Lordship, the previous order passed by this Honorable Court is in my appeal petition last page, Your Lordship, in page number 29 and 30. Main appeal, 29 and 30.
Also, there is another IA. Just write like this. IA criminal 7 of 2026 has arisen out of an application filed by the applicant under 419 subsection 4 BNSS, seeking leave to file criminal appeal against acquittal, against judgment and order of acquittal dated 26/8/2019, passed by learned CJM Aizol in complaint case number 105 of 2013. You are the complainant.
Yes.
And the applicant is stated to be the complainant in that proceeding. Full stop. It appears that there is also a delay in preferring the said criminal appeal, for which another interlocutory application has been filed, giving rise to IA criminal 8 of 2026. That has not been listed today actually, because it has to be completed. First it has to be completed. The applicant shall take steps of notice upon the sole respondent. List the matter after 4 weeks. No, after 4 weeks.
Oblige.
At this stage, no record is necessary. First, let us.
Item 20.
(2021) is same.
Same, Your Lordship. And also this IA is for application for condonation of 17 days in the connected criminal revision petition, Lordship. Then, Lordship, yesterday, Your Lordship had observed that whether this type of case can come under the criminal revision petition.
Not bail.
Yes, Lordship. I have checked it. Then I think Your Lordship is correct.
I think
yes. Then
we can
as
all
per
be
this,
wrong, of course.
Yes, these are wrong.
But I think revision won't lie. But you're not remediless.
Yes,
Criminal
it should
petition.
be under criminal petition, Lordship. Here, section 438, subsection 2 clearly says that this kind of case interlocutory
Modify the
application-
petition then. What do you say?
Lordship, this kind of case should be under the criminal petition.
Petition, yes.
So I may be allowed to withdraw the case and to file afresh. And Lordship, I may be allowed to take back the annexures which I have submitted, especially that certified copy.
You will need it. Mr. Learned Counsel submits that perhaps the main proceeding ought to have been filed as a criminal petition invoking the provisions of section 528 BNSS instead of being preferred as a criminal revision. Full stop. In this context, he seeks liberty to withdraw. He seeks permission to withdraw this proceeding along with the IA, with a liberty to file afresh. A liberty to file afresh as a criminal petition. He also seeks permission to take back the annexures, including
all the annexures.
certified copy.
Certified true copies. Yes.
The prayer is allowed. Full stop. The instant proceeding, the instant IA is disposed of upon withdrawal
Lordship, yes.
with the liberty indicated above. Same order.
Same order, Lordship.
2021, madam, same order. Okay. Now we'll have a hearing. You can leave.
Admission, item 21, 12, sorry.
Same. We have a hearing, ongoing hearing. 2021 is same. Same.
Your Lordship, with apologies, my Lord, before my learned friend starts his argument, Your Lordship, With apologies, my lord, before my learned friend starts his argument.
No, sir.
May I clarify one point, your lordship, because I have made a bona fide mistake regarding the staff service rules, which I have stated as silent on this date of birth. But if I may take your lordship to page 7 of the affidavit in opposition, my lord.
I'll just, where's my note? Give me a stapler. It's stuck. No, stapler, small stapler.
Okay. My lord, page 7 of the affidavit in opposition.
Yeah.
My lord, counting from the bottom of the page, 5th line, it starts with as per rule 39.5. Has your lordship got it, my lord? Counting from the bottom line. As per rule 39.
I'm on page 7.
7 of the affidavit in opposition. Respondents counter affidavit, my lord.
Right. Oh, this is the writ petition. Yes. The affidavit in page 7.
Page 7, counting from the last line at the bottom of the page, my lord.
As per rule 39.
As per rule 39, sub clause 5 of the Staff Service Rules 2011, the date of birth of all employee on his first appointment shall be recorded in all documents by Christian era, supported by documentary proof such as birth certificate or HSLC certificate, which shall not be altered except in case of clerical errors. The managing director may, however, allow alteration in exceptional cases if he is satisfied of the correctness. This is what I would like to emphasize, my lord. This is what the Staff Service Rule says. It says that, yes, if there is any clerical errors, then it can be rectified on the basis of the documents like birth certificate, HSLC certificate. But the managing director, this is the respondent number 2, he is also the chief executive officer, my lord. He has the power to allow alteration in exceptional cases if he satisfied the correctness. Then this is exactly what happened in the present case.
After repeal, this rule 108 was inserted.
Yes, this is. And
provides that no special.
That correction happened before the repealing act came into existence, man.
It was last, file noting which we saw, that was last approved by the MD.
MD, CEO, this is the same thing, my lord. Same post, same authority. Managing director and the CEO. So, my lord, the point is that the present case is not the case where the petitioner at the fact end of his service is applying to correct his date of appointment. It was already corrected by the concerned authorities of the employer, and now the employer is the one who is trying to deny the already rectified corrected date of birth. So, my lord, with this, as of now, I'll conclude my submission with reservation to rebut if necessary, my lord.
Sure. You can reply.
May I please, your lordship? My lord, to recapitulate the facts narrated by my learned friend, for my benefit, if I may point a few facts. Now, the petitioner joined service on 28/2/1991. Now, at the time of joining service, he entered his date of birth as 24/2/1966. The petitioner has realized
28 to 1991.
24 to 1966 is the
No, he joined service in 91.
28 to 1991.
Yeah, go ahead.
Now, petitioner substantiated his age proof by submitting HSLC, wherein his date of birth was recorded as 24 to 1966. So there is the date of birth submitted by him at the time of joining service. Now, before I move on with the facts, your Lordship may allow me to point out Note 6 of Rule 56, my Lord, which of the fundamental rules, my Lord.
FR?
FR.
FR 56.
Note 6. In my book, it's page 265. Whether my book
Should be same.
Yes, my Lord.
Let's see. Otherwise, we'll harmonize it. 265.
Yes, Note 6. Now here it's
Note 6.
specifically referable to the government survey, my Lord. But I'll come back with my service rules.
No, I think it's slightly different in my case.
Now, here in this case, without reading the...
Which is the subject, your topic?
The subject
Our
I'm talking
page numbers
about
are different, I think.
is...
Rule FR 56.
Yes, my Lord.
FR 56.
Note 6.
No, yes.
Now here also, if a government servant wants to change his date of birth, he has to make a request within 5 years of his entry into government service. That is what the law says and applicable to government servants. If your Lordship may kindly come to SSR 2024, that is the Staff Service Rules 2024, which governs the present employee and the employer, my Lord.
Staff Service Rules.
Staff Service Rules 2024. I will also come with the previous rules.
This was, this is pertaining to the Staff Service Rules?
Pertaining to the petitioner and the respondent hearing.
Of the bank?
Bank, yes, my Lord.
Bank's Rules 2024.
Yes, my Lord.
Right. Then
Now I'll come to Rule 39A, subclause 1.
Rule 39. Rule 39, yes.
If, with your Lordship permission, may I read this? A service book shall be maintained for each employee of the bank from the date of his or her first appointment to the bank. It shall be kept in the custody of the head office. Every step in an employee's official life must be recorded in his service book, and its entry must be attested by the head office or her office, or if he himself is the head of an office, by his immediate superior. The head of office must see that all entries are duly made and attested, and the book contains no eraser or overwriting. So here, your Lordship will see that there is an overwriting. The year 1966 was overwritten by 1968.
No, it was cut.
Yes.
It was cut.
It was cut. It was simply cut. And as your Lordship has pointed out earlier to my learned friend, there is no administrative order which substantiates the fact that we have approved or validated the note sheet written by the CEO. And to that effect, I have an authority, my Lord. Lordship may come at paragraph 5 of Rule 39.
Yes.
Sub-Rule 5, my Lord.
39A.
39A, Sub-Rule 5. With your Lordship permission, the date of birth of all employees on his first appointment shall be recorded in all documents by Christian era, supported by documentary proof such as birth certificate or HSLC certificate. an employee can only change their date of birth within 5 years of entering service of bank service. This can be done with approval of managing director, which is the chief executive officer as well. My Lord, rightly or wrongly, let us assume first that my learned friend date of birth was changed subject to the approval of the CEO. However, if your lordship will kind...
Another thing I just want to ask before we go forward. This staff service rules of 2024, when the purported correction was made in 2016.
Yes, my Lord.
What was the previous rules?
2020 was there, 2011 was also there. I'll come to that, my Lord.
We'll see that if
yes,
necessary.
I'll
Later
have
on,
the book.
As you go on, we'll see that also.
Yes, my Lord. Now, my learned friend, the petitioner's date of birth was corrected. Let us assume, rightly or wrongly. Now, on what basis? It was altered by the DGM on 15/4/2016. That was on the basis of an affidavit, 8/1/2016. The DGM then, rightly or wrongly, he insisted the petitioner to come with a court order. That was not disputed. Now, this affidavit is not a court order. Now, due to the misrepresentation of facts, we can assume that this DGM has altered the date of birth of the petitioner from 1966 to 68. That is how many years? After how many years, my Lord? That is after 24 years.
Of his service.
Yes.
Of his joining service.
Rightly or wrongly, he has to make a request within 5 years. And that DGM, rightly or wrongly, he should have also rectified within a period of 5 years. This thing has been done after 24 years. That is in violation of our specific rules and Fundamental Rules 56 Note 6, my Lord. Your Lordship may kindly see Annexure 21 of our affidavit in opposition.
Page?
Page 21, Annexure 2. Your Lordship will see that there is a signature of government servant at the bottom, named Cillian Luna, and the signature is at the last, as Your Lordship see, page 21.
Yes.
Yes. Now, here, the date of birth as recorded is 24/2/1966. However, it was crossed, and there's another year written 24/2/1968. Now, what does the service law say? The service law which I am referring right now says that there should be no overwriting, or there should not be no erasure, my Lord. My Lord, allow me to read so that I may provide the books later on, my Lord. In the Staff Service Rules 2020, Rule 39, my Lord, I'll just read and I'll pass on the book, my Lord. Here, it also says that all entries are to be duly made and attested, and the book contains no erasure or overwriting, and all corrections being neatly made and properly attested. And the Rule 5 is also the same. If I may provide the books, my Lord.
Yes, I have.
I'm on Rule 2020, my Lord. I'm coming back. Now, the rules which has been provided in 2024 was also there in the previous rules. I'll also provide 2011.
Yes. Okay.
Your Lordship will see that the provisions are the same as in the other rules as well. Now coming back to my point of facts, my Lord, Your Lordship may kindly come to 23 of my affidavit in opposition. As Maharana Friend has already pointed out that this date of birth was recorded before his date of birth was changed. It is in the year 1994. However, the date of birth remains the same, which has been acknowledged and signed by the petitioner, Madam, which is 1966. Again,
But this documented page 23,
yes,
which was also shown by him, it was prior to this
correct,
exercise.
correct.
You know,
Prior
rightly or
to,
wrongly.
prior to
Rightly or
exercise
wrongly.
made on the basis of affidavit. However, the fact remains the same that his date of birth, as written by him, is 1966, which corroborates the stand that his date of birth was 1966. Now at page 25, the Lordship will come again from the nomination and declaration form. His date of birth was again written 24/2/1966. And the date was 1997, the nomination form, which also corroborates the fact that his date of birth was 1966. Again at page 27, it's the same. So the stance of the respondent from the date the petitioner joined his service in the year 1991 till date is 24/2/1966. I am going to repeal the submission of my learned friend that we do not seek to change his date of birth at the end of his career. What we accept from the date of his joining service till date is 1966. Now, as per our rules,
But the thing is that, okay, we proceed.
Yes, Madam.
2016, this, this.
The DGM.
The correction was made, but.
It was due to misrepresentation of facts.
Anyway, it was done by DGM.
DGM. And I would also like to repeal the submission of my learned friend that the CEO had written approved in the note sheet.
Had approved. No.
It was my learned friend's submission which was not denied, but whether that note sheet had sanction of law, I will repeal his submission, Madam. Now, I'm asking myself, why should the CEO issue an administrative order or circular or instruction? It is because there are other employees who might have been affected by the change of date of birth. Now, as per Rule 4 of the SSR
of 2024.
Rule 4 subclause C. Your Lordship will see this. The CEO, who is the managing director, is empowered to issue such administrative instruction as may be necessary to give effect to and to carry out the purpose of the provision of these rules or generally to secure effective control of the staff, which means that in our service rules there are provisions which says that date of birth can be changed within 5 years of entering bank service. Now, on reading this rule, we can see that there has to be an administrative instruction or order to validate
No, to change any clauses of the service rules.
Yes.
Okay.
To carry out the purpose of the provision of these rules or generally to secure effective control of the staff. Rule 4 subclause C. Rule 4 subclause C, Madam. Now, before I go further with the facts, allow me to cite the authority which I'm relying upon, 2009-15 SCC 705. SCC 705. Page 726. My Lord, in the meantime, may I read? A noting recorded in the file is merely a noting, simpliciter, and nothing more. It merely represents expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. Now, to treat the decision of the CEO as valid, there has to be an administrative instruction or order, my Lord, in this case, taking a cue from this order, my Lord.
Actually, you know, just to make my observations here. It's okay. We can take it up later.
2009-15, volume 15, SCC 705.
No, I'll see it later, no issues. What I'm saying
Yes,
is
madam.
that can a endorsement in the service book regarding date of birth, you know, rightly
Yes.
or wrongly, be called a file noting? I think it is more than a file noting.
No, there is a file noting which has been relied by my...
Yeah, that is a
friend.
file noting.
Yes.
But the endorsement in the...
It cannot be overwritten.
Secondly, yes, administrative order, you are very right actually.
Yes, madam.
That it has implications for, because date of birth has a relation, strong relation with seniority.
Yes,
and
madam,
seniority,
that's exactly the
point. Seniority is a collective issue.
It affects the rights of the other
It's always,
parties.
you know, before you, behind you, and all that. So now, my point is, it should have been the other way around actually, that once a person's request for changing of date of birth
Yes, madam.
is accepted, there should be an administrative order.
Yes, madam.
And that administrative order should also say that this is, date of birth correction is allowed.
Yes,
And
yes,
pursuant to allowing of the same, necessary corrections will be made in the service book.
Correct, my Lord. So the action
In
taken...
a way.
Yes.
In
Your
a way,
Lordship-
that ideally that should be.
Your
That
Lordship is
first
right.
administrative order, and then the file notings. The file notings which then the service book entry. The file notings which he has shown, you know, those would be there.
Yes.
Ideally, if I'm not wrong, the sequence should be something like this.
Yes.
That file notings approving the change in the date of birth.
Yes,
file
madam.
noting is there. The file noting is, you know, it is formalized in an administrative order.
Yes,
And
madam.
after the administrative order,
It has to correct.
the
It has to be
service book is corrected.
That
accordingly.
is exactly why we are saying that there is no estoppel for us if anything wrong
Ideally,
was-
you know. But
there can be no estoppel against law, my Lord.
anyway, now what should we see?
Now, I'm referring to the Supreme Court judgment 2009-15 SCC 705, para 43, page 726.
Para 42.
Why I'm relying upon this is the principle which has been carved out by this judgment. A noting recorded in the file is merely a noting, simpliciter, and nothing more. It merely represents expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. Now, if your Lordship may come at page 727 in the same paragraph. A noting or even a decision recorded in the file can always be reviewed, reversed, overruled, or overturned, and the court cannot take cognizance of the earlier noting or decision for exercise of the power of judicial review. My learned friend was aggrieved by the fact that there was no review of the decision taken by the previous officers, that his date of birth was changed from 1966 to 1968. But what has been noted by the Honorable Supreme Court is that it can always be reviewed, reversed, overruled, or overturned. Now, with regard to...
Let us read this line again.
Yes,
a noting or even a decision.
A noting or even a decision recorded in the file can always be reviewed, reversed, overruled, or overturned. Why I'm relying upon this is that my other friend has submitted that the CEO has written approved in the note sheet. And the court cannot take cognizance of the earlier noting or decision for exercise of the power of judicial review. Madam. Now, if your lordship may look at 2007-2 SCC 491. 2007-2 SCC 491. Page 501, para 19. Your lordship may come directly to 3 lines from the bottom.
Page?
Page 501, para 19.
Okay.
With your lordship permission, I'll read this. Any department letter or executive instruction cannot prevail over statutory rule and constitutional provisions. Now, what is the rule with regard to change of date of birth in the service record? As per the 2024 rules, as your lordship has noted, within 5 years of entering the service. Now, any instruction or letter cannot validate that action, madam, if it violates the statutory rules. Now, another citation, my lord. 2010, 10 SCC 677.
Uh, 677?
677, my lord.
Okay. Para?
Now, the relevant portion is para 32, my lord. It is a settled legal proposition that if an order is bad in its inception, it does not get sanctified at a later stage. A subsequent action development cannot validate an action which was not lawful at its inception, for the reason that the illegality strikes at the root of the order. It would be beyond the competence of any authority to validate such an order. It would be ironical to permit a person to rely upon a law in violation of which he has obtained the benefits. My lord, let us assume that the authorities of the bank has changed the petitioner's date of birth. Rightly. But it was changed after 24 years, which is in violation of statutory rules. So here there is no order. There is no order issued by the bank that his date of birth has been changed from 1966 to 68. Here it says that even if there is an order, if it's bad in its inception, it cannot be sanctified, my lord. Allow me to continue, my lord. Two 2002 through GLT 94. 2002 to GLT 94. I may just state the brief facts of that case, my lord. In that particular case which I'm referring, the petitioner was appointed as Gram Sevak. In the year 11/3/1958, his date of birth in his service book is 1/3/35. Now the Director Agriculture recorded his date of birth as 1342. State respondent retired the petitioner from service on 31/5/96. Now what the court says, Honorable Court says, is that action taken by the Director changing the date of birth of petitioner is null and void. Your Lordship may come at page 4.
Yes.
Page 4.
Page 4.
Page 4, 7 lines from the bottom of the paragraph.
Is para 6.
Yes, para 5, my lord.
Okay.
7 lines from the bottom. I'll start from 7 lines. With your Lordship permission. In this case, the respondent entered into government service on 11/3/58, whereas the Director of Agriculture Government of Mizoram altered the date of birth of the respondent number 3 on 3/10/77 on a request made beyond the 5 years period stipulated in paragraph A in note 6 to FR 56 quoted above. Hence, such an alteration made by the Director of Agriculture Government of Mizoram was not authorized by the aforesaid note 6 to FR 56 and was a nullity in law. So this change of birth certificate, which was not as per the rules, is a nullity in law. Even if the DGM may have corrected the date of birth, but it was not corrected within the stipulated period of 5 years, which the Honorable Court says is a nullity in law. Now, in 1999, 1 GLT 45.
The respondents obviously do not dispute that the date of birth was altered, but your contention is that such alteration was
it is not as per law.
Unauthorized and illegal.
Yes, my lord. And we do not seek to change the date of birth at the fact end of the career of the petitioner. We accepted right from the petitioner's entering into service till his date of retirement, that is 24/2/1966, is still the same, my lord. Now here, my lord, Swadesh Ranjan Dey versus State of Tripura, 1999, 1 GLT 45.
Just a minute. Just a minute. This is a High Court decision.
This is High Court decision, Agartala bench. Now, in this case, there are several dates of birth submitted by the petitioners in this case. And there are different documents such as admit card, school final examination. And what the Honorable Court has decided is at page 2, my lord.
Page 2.
Page 2, para 5, my lord. This is a writ appeal coming from the judgment of the single judge, which affirmed the judgment of the single judge, my lord. May I read, my lord? 5 lines from the top, my lord. 5 lines from the top of paragraph 5. The learned single judge also came to a finding that the petitioner had himself declared his date of birth as in March 1938, and this declaration has been signed by the petitioner as well as the Circle and Assistant Settlement Officer of the Survey and Settlement Department, Government of Tripura on 16/5/1960. On this finding, the learned single judge held that the declaration of date of birth as given by the petitioner at the time of entry in the government service shall prevail, and the date of birth reflected in the admit card and the school final examination certificate cannot unsettle the said declaration. Now what this Honorable Court says is that what document has been submitted at the initial stage will prevail over the other documents which has been submitted. Now my learned friend has submitted the judgment of the Honorable Supreme Court.
What was the finding on regard to principles of natural justice? Because one of the contentions he has made,
yes,
that suppose we go through all these things, and we do not go into the merits of the alteration or whatever.
Yes.
But since it is a fact, that the date of birth remained in the service book as 68 for a couple of years,
yes,
since 2016.
Yes.
So when effect was sought to be, when it was proposed to retire him on the basis of the 66 date of birth.
Yes, Madam.
Don't you think the principles of natural justice or hearing some notice required to be given? Therefore, I was interested in, there was a similar argument was made in this case also.
I'll come to page 46 of the writ
Just
petition.
make a note of it. With this,
Page 46 of the writ petition, Madam.
Leaving aside other things,
Yes.
don't you think hearing a notice was necessitated? Something of that sort.
We'll come to that,
This is
Madam.
one of the things that come to my mind. And of course, he had made a contention. That's his contention. Okay, next.
Page 48 is the type copy of page 46.
I should come to page
48, Madam. Of the writ petition.
Page 48 of the writ petition.
Now I'll read this, Madam. Second paragraph.
Page 48.
Yes, Madam. No, I'll start from the beginning of the application, Madam. I am requesting you to kindly accomplish my application. I joined Apex Bank as a clerk cum cashier on 4th March 1991. About a year after working in the MCAB at the main branch, I received a phone call asking you wrote 1968 as your birth year in some documents, whereas in some others it is 1966. Which one is correct? 1968 is my correct birth year. In all my certificate except my matric certificate, it is written as 1968, that is why I'm referring to the matric certificate. My birth year in my matric certificate is not correct, and I told him that in my PU certificate, which I also submitted, my year of birth is 1968. The qualification required when I joined my service was PU, second division, so I submitted my PU certificate. While I believe that my date of birth in my service record was 24/2/1968, and that my time of pension would be in February 28, the staff service record published in 2013 recorded my time of pension as February 2026. My Lord, if with your Lordship permission, may I pause at this moment. This is the letter written by the petitioner on 4/9/2025, which suggests that he knew about his year of pension on February 26 by stating that it was published in the service record in 2013. Now let us minus 2013, minus 2023, 25. It is 12 years.
Matric certificate has been corrected. There's a statement, the last line, last line of page 48.
The qualification record when I joined my service was PU, second division, so I submitted my PU certificate. PU means 12. Now, what I'm trying to impress upon your Lordship is that the petitioner knew about his date of retirement on February 2026, which he said that it was recorded in the staff service record published in 2013. Now, what was the grievance taken up? It was taken up in 4th September 2025. Your Lordship will see that 2025 minus 2013 is 12 years. He should make a complaint within a period of 5 years. But that is after a lapse of 12 years, which he knew that his date of birth in the service record was altered. It was published in 2013 that his date of birth, his time of pension, superannuation pension is February 2026. So that means he has not taken any action. So there is no merit in the case of the petitioner, and with your lordship query that there should be violation of natural justice principle is what I'm trying to address upon, that he knew. So what is the point of invoking that natural justice principle when he has himself done something wrong? And with regard to the citation relied upon by my learned friend, the Honorable Supreme Court, wherein it says that the employee should not make a request belatedly at the back end of his career, equally applies to the employer. My submission is that this is not a case where we sought to alter the date of birth of the petitioner. Our main contention is that the date of birth of the petitioner is 1966. Till date, it is 1966, because that is the time when he had, at the time of joining his service, he had recorded his date of birth as 1966. Now, in the case of that circular, which was relied upon by my learned friend, the petitioner therein, he sought for a voluntary retirement scheme, and if his date of birth was altered, he could have received more benefits. In our case, there are no other benefits other than the benefits of the year which can be enjoyed. Has he changed his action by altering, has we changed the action? So we are not barred by the principle of estoppel. And this judgment, which has been relied upon by my learned friend, does not apply to the present case. Because in that case, initially, after joining his service, in the case of Sankarlar, my lord, his date of birth was not recorded initially when he entered the service. It was recorded only after 5 years. So there was an error in recording of date of birth by the authorities in that case. Now, Supreme Court says in that case that employee alters the record at the end of the career. But in our case, we do not enter the date of birth of the petitioner at the end of the career. Now, in the case of that Sankarlar, it was due to the financial benefits which could be received by the petitioner under voluntary retirement scheme. So, in that case, Article 300A was also involved. So that case was distinguishable to this case. Now, with regard to that, if your lordship may permit me to rely again the Honorable Supreme Court judgment in 2004, 8 SCC 579.
2004?
2004, 8 SCC 579.
Take this, huh? Just take this. Only signature. You could take this. I've written it down, the citations. Yeah. This is a famous case, huh? Bharat Coking.
Yes, Mother. Page 584. Para 9. Page 584, para 9. With the permission of the court, I'll read this. Court should not place reliance on decision without discussing as to how the factual situation fits.
Where?
Para 9, page 584.
Para 9.
Yes, madam.
Para 9 only. How does the para 9 start? This court has consistently.
Court should not. My lord, it should be Bara Petroleum Corporation Limited, 2004.
Para 10. No.
Para 10.
this court has consistently held? Does it start like that? The
It
sentence?
starts with courts should not place reliance. My lord, I'll read this and I'll give the copy, my lord. I'll give you.
The case name is Bharat Coking Coal. No, this is a different citation. Sorry. 2023 SCC 411.
2004.
Oh.
2004 HCC.
This is a different citation. Maybe you'll rely on it later on. Yes, Bharat Petroleum.
Yes, my lord. Page 584.
Para 9.
Para 9.
Court should not.
Court should not place reliance on decision without discussing as to how the factual situation fits in with the fact situation of the decision on which reliance is placed. Observation of courts are neither to be read as Euclid's theorems nor as provisions of a statute, and that too taken out of their context. These observations must be read in the context in which they appear to have been stated. Judgment of courts are not to be construed as statutes. To interpret words, phrases, and provisions of a statute, it may become necessary for judges to embark into lengthy discussion, but the decision is meant to explain and not to define. Judges interpret statutes, they do not interpret judgment. They interpret words of statutes, their words are not to be interpreted as statutes. At paragraph 10, Lord Reed said, Lord Atkin's speech is not to be treated as if it were a statutory definition. It will require qualification in new circumstances. And I'll jump to para 12, my lord. The following words of Hidayatullah Justice in the matter of applying precedents have become locus classicus. Each case depends on its own facts, and a close similarity between one case and another is not enough, because even a single significant detail may alter the entire aspect. In deciding such cases, one should avoid the temptation to decide cases, as said by Cardozo, by matching the color of one case against the color of another. To decide, therefore, on which side of the line a case falls, the broad resemblance to another case is not at all decisive. Precedence should be followed only so far as it marks a part of justice, but you must cut the dead wood and trim off the side branches, else you will find yourself lost in thickets and branches. My plea is to keep the path to justice clear of obstruction which could impede it. Now, my case and the case which my learned friend has relied upon, Shankar Lal, is completely different case. So, I would like to conclude my submission is that the petitioner could not take advantage of what might have been done incorrectly by the previous officers, which has not been sanctified by law. And to that effect, my lord, since the order or anything which does not get sanctified or is against the law cannot be accepted by this court to be valid, and that is why this writ petition has to be dismissed. That is my humble prayer, my lord.
My lord, if I'm allowed to make a short reply, my lord, I'll not take much time of your lordship's time. My lord, may I take your lordship to page 33 of the writ petition? This is the note sheet.
After something. Page 33 of the writ petition.
Of the writ petition, my lord. This is the note sheet. I have also annexed the translated copy, but I just want to show your lordship the
original,
the date. Page 33, my lord. The handwritten date is one line across the sheet is there, my lord. This is date 7/4/2016. Has your lordship got it, my lord? One line is written, page 33 of the...
In the translated or in the original one?
In the original copy, page 33.
Okay.
One line across the page is there, my lord, the first line.
Yes, in the first para?
In the first paras, just below that, one line is there, my lord. The date is 7/4/2016. The first paragraph, the signature is there. It was, the signature date is 21/12/2015, but below that, my lord, just below the line which goes across the page.
Here? Somewhere here?
Page 33, my lord.
Oh, 33, sorry.
33. Yes. One straight line is there. Just below that straight line, my lord, date 7/4/2016. Has your lordship got it?
Yes, this
Yes. This is the date when the note was started written, my lord. While what I'm trying to say is that my learned friend has said that it was the DGM who, on his own motion, corrected the date of birth on 24/2016. But that is incorrect. I would like to point out that the submission is incorrect, my lord.
No, that is, I have mentioned also CEO.
CEO, then my lord, let me come down to this page. The same page, page 33. And towards the bottom of the page, approved handwritten is there. And left side, CEO has signed, CEO has approved it. And it was approved on 15/4/2016, my lord. I think your lordship
What is
got
written
this.
in the last sentence? A service.
It has to be corrected accordingly in the service book. This is the last line. I have annexed the
It is written
translated
in
copy.
Mizo language or
Yes,
English?
yes, Mizo language. My lord, may I take your lordship to page 35?
I see.
35.
Deputy manager.
Yes.
That's your point, contention.
There is my contention.
Your
Approved.
contention that
I-
deputy manager, GGM has made it.
No, DGM has advised the petitioner to submit affidavit and a court order, my lord. Now
It was finally approved by the CEO.
CEO has written approved.
Only after approval, correction was made in the service book.
There is no dispute to the fact that approve has been written by the CEO,
Yes.
which we have also written in our affidavit.
This is an admitted fact, my lord. So,
Whether this has validity will be
all,
tested.
my lord, all what I'm trying to say is that it was DGM had not simply corrected in the service book the date of birth, my date of birth, but it was after the approval being given for such rectification, it was subsequently corrected in the service book. That is what I'm trying to point out. Yes, because, my lord, I may take a lordship to the next page, that is page 36 of the writ petition. At the middle of the page, at the right side, my lord, one seal is there, and just below the seal, the date is given. It is countersigned by the CEO, managing director.
16/4.
Yes, 15/4, my lord.
15/4.
15/4/2016.
16.
So that is after the approval, just on the date of giving the approval, my lord. This correction did not precede the approval. That is what I am trying to say. That is my point, my lord.
This correction received the approval.
This correction did not precede. Did not precede the
It
approval.
was after the
Yes,
correction.
after the approval. At the time of approval, it was instantaneously corrected, my lord. So this is quite important.
Right.
And my lord, my next reply is that what the respondents had also admitted is that correction was made in the service book. But they said that this is due to misrepresentation of facts. But if they said it's misrepresentation of facts, there is no subsequent alteration or revocation or any recorrection or re-alteration of the date of birth. Then all we have to refer to is the service book only, my lord. This is the correction. My application was also only in respect of making correction in my service book regarding my date of birth. So it was rectified and allowed and approved, my lord. So there is no subsequent revocation or whatever sort of that thing, my lord. And while saying this, my learned friend had pointed out the Honorable Apex Court's judgment, which says that maybe it's this Honorable Court's, if I'm not mistaken, this Honorable Court's order also in one of the cases. It says that note sheet is only the noting, and it can be revoked, recalled, or overruled. But nothing of that kind of thing like overruling, overriding, or withdrawing of the note, approval given in the note sheet happened in the present case, my lord. That is also a crucial point. And the next point is that he mentioned, my learned friend mentioned about the stipulated period of 5 years so and so. But Rule 39, subclause 5 of Staff Service Rules 2011, which was the rules, SS Staff Service Rules, which was holding the field at the relevant point of time, it says clearly that the managing director has the authority to make the alteration in the date of birth of the employee. And accordingly it was done. So there is no illegality, my lord. Because as I have shown to your lordship that particular service book, particular page, my lord, where the correction was made, it was countersigned by the MD, CEO, who is also the CEO. So that is quite lawful, my lord. There is no, then the respondents cannot rely upon the state government's office memoranda and other rules, because this is where I'm working is the Apex Bank is one of the cooperative societies bank, my lord. It's not one of the departments of the state government. And so, my lord, my last point is that, another point before coming to my last point, that page 48 of my writ petition, I have explained it clearly that when, after joining my service, I was asked to submit the metric certificate, HSLC certificate, and wherein my date of birth was incorrectly written, my lord. And on the basis of that only, service book was recorded, in my service book, my date of birth was recorded wrongly as 1966. That was the reason why I applied for correction, and it was accordingly corrected in the year 2016. And now, after almost 10 years, after making such correction, now the respondents are saying that we had already accepted 1966 as your correct date of birth. But there is no official communication, no opportunity of being heard was given to me, my lord. That is what I'm emphasizing on this. So, my lord, at least now, my last point will be, my lord, the one big question is there. Suppose they are saying that 66 is still your correct date of birth. Then what will happen to the correction, rectification made in the year 2016? By striking off the incorrect one and replacing with the correct one, then without any issuing of any order or without any revocation order passed by the respondents, how can they simply accept which was already replaced by 1968? So it cannot simply done in that way. Now all they are saying is that yes, it is correct that we have rectified it, change in the service book also, so they cannot simply discard the service book. The only procedure, as I have already submitted, my lord, the only procedure for correcting my date of birth in the service book is striking out and correct it physically by writing the 1968. So, my lord, all these illegalities had caused arbitrariness to me in my service. So, my lord, with that,
I'll look into it.
Yes.
Yes, Your Lordship. On behalf of the respondent number 1, if the court permits me, I will submit only one point.
All good.
Your Lordship, with regard to the...
Respond number 1. No?
Yes, that is the state respondent. And Your Lordship, what I would like to point it out is that it is clearly known that since from 2011, 2020 and 2024 service rules, staff service rules, it is clearly mentioned that all the alteration of the age can be made during the period of 5 years. So it is very clear. And now my learned friends had said that it has been altered in his service book after 24 years. So my point is that, Your Lordship, any action which is in contrary to the statutory law cannot be state that it is a valid. So in my humble opinion, Your Lordship, the action which altered the age of the petitioner in contrary to the statutory rules cannot be termed as valid. It is void. So if it is held as void, the alteration is meaningless. So if it is meaningless, that means that his age will be 1966, Your Lordship. That's all, Your Lordship.
If Your Lordship may permit me to make one small submission, even though I'm pestering Your Lordship.
No.
My learned friend has stated that there has not been overturn of what has been decided. Now, that is simply what contradicted my learned friend, because we have informed the petitioner that your date of birth could not be altered. Your date of birth originally recorded in your service book has to be 1966. Your Lordship will see that they have challenged that letter here itself. Unless there is arbitrary to them, they will not have challenged this. So that is what I would like to submit. And for my last point, a right, if any, to any person dies with limitation manner. I need not remind Your Lordship. That is why there has been a date, specific date mentioned in the service book, service rules, my Lord. Obliged, my Lord.
The CEO, you said the equivalent rank is managing director.
CEO is also managing director, my lord. Managing director, why his nomenclature designated is only in the market side, my lord.
So anyway, so I'll carefully go through it and try to give the judgment quickly, because whichever way decided, because its retirement age is coming. Okay, so I heard respondent number 1, madam, and other respondents, counsel. Arguments concluded, judgment is reserved. I deprived the other counsels of hearing your of both sides' beautiful arguments.
Thank you.
Seriously, I'm joking. But anyway, it will be, it would have kept them waiting, so I thought.
We are highly obliged.
But they can see it again if they want in the online.
Yes. We are deeply grateful, my lord.
No problem. It's my duty. So these 2 notes, this have to be tagged. Okay, you done with the. I'll get back. Not now. I might just need that rules SSR.
No, my lord can keep it.
I might need that.
Yes,
otherwise, SEC online also I have.
Yes,
I can whatever I need, I'll take it out.
No, my lord.